So another process of the tree matters. No? Fine. Yes, sir. I'm inside the box. I'm inside the box. Okay. I'm going to make it tomorrow.
Check, check.
Supplementary addition. And it's 60. Part-time.
Until last motion, after motion, it will be orders, which is a supplementary law, part itu, then normal admission. First motion, then orders. First motion, followed by orders. After that, part admission, then normal admission.
Revelation, Your Lordship.
Yes.
Your Lordship, I think to mention item number 11 to 43. That is a BL regarding the medical college.
From 11.
Your Lordship, I have a telephonic instruction, information from a learned colleagues, Mr. Mozoy, who is appearing on behalf of the medical college. So he is on leave. So, and he is supposed to be submit the updated status of the medical institution of the entire state. So I was requested to mention on this behalf for second time for 4 weeks time. So as to submit the updated status of the medical institution of the state.
Yes.
I have no objection.
I think it starts from 10.
Yes.
10 onwards. 10 to
43, my lord.
please write down. A mention has been made on behalf of Mr. N. Mozui, who otherwise has submitted his leave of absence to the effect that he is yet to receive instructions for filing the additional affidavit as directed by this court, and therefore further 4 weeks' time may be granted. The said prayer is not objected to by the learned counsel for the opposite party. To stop in view of above, list the matter again after 4 weeks on a date to be fixed by the registry.
Much obliged.
May it please your lordship. Your lordship, I crave your indulgence to mention item number 45. This is habeas corpus, your lordship. Habeas corpus, and analogous to the yesterday's number 1 matter, wherein my learned friend Lima Wapang has completed his argument.
Item number?
Item number 45, your lordship. And I am adopting the submission made by my learned friend regarding law point. Only factum, only 5 minutes it will take, Your Lordship.
You will have to wait for your turn.
My Lord,
You will have to wait for your turn.
my Lord. Huh? No, no. After,
See, thing is that we have item 60, part hard matter also.
Your Lordship, it is, I will not take, only 5 minutes I will take. I will adopt yesterday's Mr. Limau submission, same. I am for the accused number 6.
Oh, that's all right.
And
But-
it will
but-
not reach, Your Lordship. I am nearly 5 months, over 5 months, nearly 6 months I am in custody, Your Lordship. And it is the same, everything is same,
Mr. Counsel,
my Lord.
please listen to what we want to say. There are so many matters listed today, okay? So we'll go in the following manner. First of all, we'll take motion. Thereafter, we'll take the admission, the order matters.
My Lord.
Thereafter, we'll go for the part hard. One of the part hard, which is item 60, perhaps is also connected.
Yes.
So along with that, you can
Yes,
argue,
yes,
all
much
right?
obliged, much obliged, Your Lordship. Much obliged.
Thank you,
Yes.
Lordship. Lordship, I'd like to mention for item number 52 and 53. 52 and 53 are analogous, Lordship.
Okay,
Lordship, may I believe that this matter may be taken up next week?
who's for the other side?
Lordship, the other side is the state government. And Lordship, Mr.
Mr. Eliralu also has. Yes, you have no objection? All right, as paid for by the learned counsels for the petitioners, list the matter again. The next week for hearing.
Next-
All right.
Your Lordships.
Yes,
My lord, I beg to mention item number 54. Lordship, let this matter be listed after a week, Lordship. This is a consensus prayer, Lordship.
you are for the appellant,
Yes, yes.
as paid for
I'm
by
for
the learned.
appellant in criminal appeal 6 of 2020.
Okay, as paid for by the learned counsels for the appellant. Appellants, list the matter again for hearing in the next week.
One shot flash.
May I please allow you? Lordship, I beg to mention item number 50, Lordship. Lordship, if this matter can come up next week, Lordship.
All
I
right,
have taken the consent.
as paid for by Mr. Vijimomi, learned state counsel, and not objected to by the other side. List the matter again in the next week.
May I please, Your Lordship?
I beg to mention item number 56. Can
Yes,
this matter may be listed after 2 weeks?
Mr. Iralu is there.
Yes,
Any
no
objections? 2 weeks,
Yes, Your Lordship.
2 weeks.
as paid for by the learned counsel for the private respondent,
Yes, Your Lordship.
and not objected to by the other parties. List the matter again after 2 weeks.
Much obliged.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 5. Your Lordship, here we are supposed to file affidavit in reply to the affidavit filed by the respondent number 7. Your Lordship, but
Hmm.
we are yet to obtain the signature of the petitioner. So, Your Lordship, another week time will be given.
My lord, this is PIL of 2020.
Ah.
2020 filed by them. Threatening, harassing the respondent all the time, and they are asking adjournment on several occasions. I have filed preliminary objection.
Uh,
Maintain on the question of maintainability. This PIL is not maintainable, I thought.
Oh.
They are adjourning every now and then, and today, last time also they asked adjournment on several occasions. Today, they were supposed to file every Saturday. Therefore, it is listed today. And today the council is not available. There are 3 petitioners, according to senior counsel, represent the case, PIL. 1 man died. There are 4 petitioners whose father died.
What is the subject of the PIL?
Subject is, they are saying, they are alleging that contract work was allotted to me.
Right.
Without executing the work, I have received the payment. That is the allegation.
You are for the respondent number 7.
Yes.
We'll give them one last chance. One last chance. Are you filing or not?
Yes, Your Lordship, affidavit is ready. Only the signature, Your Lordship.
We'll make an observation that this is the last chance.
Yes,
All
Your
right, because last time also I think you took time.
Last time also, several occasions they said, one day my father died, tomorrow auntie died.
Despite the objection raised by Mr. Azo, learned counsel for respondent number 7, a week's time is granted to the petitioner to file rejoinder affidavit to the affidavit of the respondent number 7 as a last chance.
My lord, if it is not PIL, I don't insist, but they keep, this is tension.
This again after a week.
And
All right.
make it fix it next week.
You want a date?
No objection, Your Lordship. It can be fixed. Your Lordship.
No date
Okay.
is mentioned.
Okay, today is 14, so you can have it 21st, next Wednesday.
No problem.
Is it okay? Okay. You just continue after a week on 21st of February 2024. All right.
Much better.
For motion, item number 1.
Yes.
It is Your Lordship.
Yes.
This instant appeal is directed against the impugned order dated 2023, passed by the learned single judge bench in WPC 47 of 2020, and raise other linked cases. My lord, here the appellant are petitioning doctors having obtained license and certificates as class B practitioners in the year 97 to 98. They were granted license
Mr.
by the
Pakin
Board of-
Richabo, this is the notice has gone to the respondents. Notice,
no, my lord.
delays condone.
Yes, my lord.
Delay condone.
Yes. Not yet, my lord.
Then notice go. Let notice go.
Okay, my lord.
Heard Mr. Pakin Richabo, learned counsel for the applicant. Applicants who submits that by filing this application, the applicants seek condonation of 52 days in filing the connected with appeal against the judgment and order dated 29/2023, passed by the learned single judge in WPC number 47 of 2019. Next, better issue notice to the respondents returnable by 4 weeks.
Lordship, I'm appearing for respondent number 4.
Ms. Devika, learned State Council appears for respondent number 4. What about Union of India? Where's CGC? Petitioner applicant to take steps for service of notice upon the respondent numbers. Respondent number 1.
Yes, my lord. I have served the notice, my lord. I served the copy to Sir
To whom?
Jaren Muli.
To whom?
CCSC Jaren Muli.
To the learned CGC.
He have received on 13/12/2023, my lord.
Where is the acknowledgement?
Yes, my lord.
Okay, you are there, Mr. Muli. Mr. Z.
My lord,
Z what?
Z Enoli.
Z and Muli. Learned CGC accept notice on behalf of respondent number 1. Okay. 1 only, is it? Applicant to take steps for service of notice upon the respondent numbers 2, 3, and 5 by registered post with ADD within 3 days. List the matter again after 4 weeks. Respondents will be at liberty to file objection, if so advised.
My lord, there are 2 cases, item 1 and 2.
For motion, item number 2.
How many days delay was that in the previous one? Huh? Almost, how many days? 54. Okay, then similar order. Similar order in this case also, okay? Next case.
For motion, item numbers 3 and 4.
May it please your lordships. Your lordship, in the present IA, there has been a delay of 196 days in filing the connected with appeal, your lordship.
Notice should go. Ms. P. Terry, Leonard counsel for the applicant, submits that by filing his application, the applicant seeks condonation of 196 days delay in filing the connected appeal against the judgment and order dated
27/6/2023,
27/6/2023, passed in WPC number
305 of 2021.
305 of 2021. Next para, issue notice to the respondents returnable by 4 weeks. Mr.
A. Tipapong,
A. Tibafom, Learned State Council accepts notice on behalf of
all the respondents.
Accountant General also.
No. 1 and 4.
Respondent numbers 1 to 4. As, and therefore, formal notice not required. However, the applicant shall serve requisite extra copies of the application to Mr. A. Tibafom within 2 days. Then AG, is there a standing council?
Yes, ma'am.
Who is the standing council?
Earlier, N.
Current-
Mozoy-
Currently,
N. Mozoy was appearing, and Joshua. They have 2 standing counsel. One is
petitioner
Joshua.
or applicant to takes, applicant shall serve notice to the respondent number 5 to the standing council, Accountant General Nagaland. And thereafter submit the acknowledgement receipt to the registry as proof of service. To stop, in case there is no standing counsel, the applicant shall take steps for service of notice by registered post with ADT within 3 days.
Much of this.
Yes, your lordship.
For motion from the supplementary clause, please. Item number 57.
May it please your lordships. Lordships, this matter is pertaining to a habeas corpus petition for detention under the NDPS. And lordship, during the time of pendency before this honorable court, there has been an extension in my detention, lordship. for which,
Page,
lordship, the detention order is at page number 7, my lord. Since I have not incorporated this in my writ
so
petition,
we'll allow you to incorporate this.
Lordship.
You'll have to file a
Lordship,
recast.
I'll file a recast.
Heard, Mr.
Lordship, I beg your indulgence. This matter, actually it's fixed for admission as item 47 today, Lordship. So since I may be given 3 days time to file a recast petition and the matter being a habeas corpus, if my lord may consider listing this in a week's time again,
Item 47.
Lordship.
Your name, please.
Alizo Kiri.
Heard, Mr. Alizo Kirek, Learned Counsel for the applicant, who submits that by filing this application, the applicant seeks incorporation of the order dated 24/1/2024 in the connected habeas corpus petition filed by the applicant, which in fact is listed as item number 47 in today's cost list. To stop, the Learned Counsel submits that since the incorporation of the extension order of the detention of the applicant is necessary, the prayer for incorporation of the same may be allowed. Upon hearing the Learned Counsel, for the parties, we are inclined to allow the prayer. To stop, the application accordingly stands disposed of with a permission to the applicant to incorporate the order dated 24/1/2024 in the connected writ petition. Next, in the main, you write item 47, okay? In view of the order passed today in IA criminal number 5 of 2024, the petitioner is allowed to incorporate the order dated 24/1/2024 in the writ petition. To stop, the petitioner shall file a recast writ petition within a period of 3 days.
3 days,
List the matter again
in a week's time. My lord.
after a week as paid for.
For motion, item numbers 58 and 59.
May I proceed, Lordship?
Yes.
Lordship, this IA is filed seeking for implementation of the Ministry of Education as correspondent number 5 in WPC 123 of 22, Lordship.
Which ministry?
Ministry of Education, Lordship. Earlier
Minis-
it was known as Lordship, Ministry of Human Resources, Lordship. Lordship, I have annexed the order of changing the nomenclature at Annexure A, page 17, Lordship.
Before it was Ministry of Human Resource
Lordship.
Development.
Yes, Lordship.
Now it is Ministry of Education.
Yes, Lordship.
That is why we were wondering in the permission granted by this court, it was Ministry of Human Resource Development.
Lordship.
Okay, now that explains it.
Lordship.
Then you'll have to file a recast.
Lordship.
Your good name?
Mika H.A., Lordship.
Miss Mika H.I., learned counsel for the applicant, who submits that by filing this application, the applicant seeks implementation of the Director, Ministry of Education, bracket, Shiksha Mantralaya, close bracket, Department of Higher Education, New Delhi, as respondent number 5 in the connected writ petition, that is WPC number 123 of 2022. You'll get this in page 15. To stop, the learned counsel submits that implement of the said party was in fact already permitted by this court by order dated 22/1/2023, passed in the main writ petition. So the learned counsel further submits that the Ministry of Education was earlier known as Ministry of Human Resource Development, but the same has been changed by the order dated 18/8/2020 of the Ministry of Education, bracket Shiksha Mantralaya. Stop, the learned counsel submits that the implement of the said party is necessary for effective adjudication of the matter. Stop, in view of above, the Director, Ministry of Education, Shiksha Mantralaya, Department of Higher Education, New Delhi, is allowed to be implemented as respondent number 5. The IA stands disposed of as allowed. Then in the main appeal, right? No, it's writ petition. In view of the order passed today in IAC number 13 of 2024, Director, Ministry of so and so is hereby allowed to be implemented as respondent number 5 in the writ petition. I think you can only change the post title instead of
We are directed to file recast petition.
us.
Yes, Lordship. There's a notification, His Lordship.
Okay, the petitioner shall file recast writ petition incorporating the respondent number 5 as party respondent within a period of
3 days, Lordship.
3 days. This is the matter again after a week.
Lordship. Much obliged, Lordship.
For orders, item number 48.
No, His Lordship, Lordship, on the last occasion, this court has directed the state to produce the status report of the work. Your Lordship, I'm placing the status report.
This is PIL number 2.
Yes, Your Lordship. So, Your Lordship, the work is under progress. Is in full swing, Your Lordship.
See, before that, what about notice to respondent number 5?
Lordship, on the last occasion, I was directed to serve notice to respondent number 1 and 2 through Dusty. I've taken necessary step, through registered AD, I've taken necessary steps. And for respondent number 5, I've taken steps through registered AD as well as Dusty. But for Dusty, the respondent number 5 has refused to accept the delivery.
You were permitted to do so by which order?
By order dated 22/11/2023, my lord.
Okay, 1, 2, and 5 by registered post with AD.
Yes, my lord.
And for 5, you were additionally given permission to affect Dusty notice. Correct?
By way of registered AD as well as Dusty service.
And that's what we're saying. So what has
Yes, ma'am.
happened then? You have taken steps both
Yes,
ways.
I've taken step for 3 of the respondents, but for respondent number 5, service through registered AD has been affected, but by way of Dusty, the respondent has refused to accept the delivery.
You took steps by registered post with AD on respondent number 5 also.
Yes, my lord.
But that is not reflected in the order sheet. In the office note, it is not reflected. Okay, when did you take? It was for the second time, is it?
Yes.
For the second time.
Initially, when the service was served through Dusty, the respondent had accepted through legal counsel. But this honorable court has, since there was no seal and name of the legal counsel, I was directed to reissue, to serve notice again.
No, see, is there any document which to show that he has taken register step on respondent number 5? Because the office note does not indicate. It says that 1 and 2 you have taken by registered post. 5
Yes,
you have taken Dusty, but you have not filed the affidavit. That much.
My lord, then.
But you say that you have taken steps by registered post.
Yes, my lord.
Upon respondent number 5 as well. That
Yes,
is not
ma'am.
reflected here.
My lord, then I have to check the status.
And secondly, what about the Dusty? You said he has refused,
Yes, my lord.
but why don't you file an affidavit
Yes, I'll file the affidavit.
saying that he has refused? Although I have approached, he refused. Then we'll see, we'll pass necessary orders.
My lord, in such instances, it is to be deemed served when the respondent rejects the acceptance.
Provided you file the affidavit saying that,
My lord, then I'll file the affidavit.
you have to file an affidavit saying he refused.
Yes,
Then we'll take that into consideration.
yes, my lord. If 1 week can be given to me, I'll file the
Okay.
affidavit.
Then what about 5? That you have to find out, because the office note does not reflect anywhere that you've taken registered post, steps by registered post date.
Yes, my lord.
Now, coming to Ms. Shukre's submission, what is this?
Lordship, the status report, because this court has directed me to obtain the status report and address this court. So, Your Lordship, now the work is in full progress and
Please file an affidavit. Please write down office note dated 15/1/2024 indicates that affidavit regarding dusty notice served upon respondent number 5 has not been filed. Stop. Again, office note dated 12/2/2024 indicates that return service report from respondent number 1 and 2 are awaited. Next para, Mr. Your good name?
K. Arka, my lord.
K. Arka, learned counsel for the petitioner, submits that respondent number 5 has refused to accept the notice sought to be served by way of dusty. Stop. He further submits that steps was also taken by the petitioner for service of notice upon the respondent number 5, apart from respondent number 1 and 2. Stop. However, the records does not reflect that steps was taken for service of notice upon respondent number 5 by registered post with AD due. Stop. The learned counsel shall verify the same from the registry. Stop. The learned counsel shall also file an affidavit regarding the outcome of the notice sought to be served by way of dusty within
1 week.
Within 1 week. Next para. Ms. V. Shukre, learned additional AG, submits that in terms of the last court's order, she has received the instructions about the latest status on the work carried out in tending to Leke Road, correct? From the Office of the Chief Engineer, PWD, bracket R&B, Nagaland. Stop. The learned additional AG is permitted to file the latest status report by way of an additional affidavit. Stop. The affidavit be filed within a period of 2 weeks. List the matter again after 2 weeks.
Lordship, I may be allowed to take back the original.
Surely you'll take back.
Lordship.
I'm not keeping it.
Lordship, Lordship, like-
Much obliged.
For orders, item number 49.
Yes, Mr. Counsel.
My lord, please, your lord. Here the respondent, the CGC is supposed to receive instruction.
See, generally, if the matters are listed for orders, it has also something to do with the service
Yes, ma'am.
upon the respondents also. So you should check it out from the file, why it is listed.
My lord, because respondent number
Have you checked up?
State respondent had filed their affidavit and in which it indicates that center has to clarify as to whether pending like the
See, we're not on the subject of the matter. I'm asking you about the office notes. Office note indicates that respondent number 5 has refused to accept the notice. You should check all these things. That is why it is listed for orders today. Now, if we proceed with the matter on merits,
yes, my lord.
without bothering to check about the notice being affected to the parties, ultimately, when these things come up, you'll go back to square one again.
My lord, on the
So-
last occasion, it was awaiting.
Who is respondent number 5? Mr. Yangavati, you represent which respondent?
My lord, respondent number 5 is the NBTC. Represented by director.
Worship, the main respondent here will be the mission director, respondent number 2.
How do you say represented by director? You have not even mentioned the director in your cost title. You come to page number 3. Page number 3 of a writ petition.
My lord, what has happened here is on the initially the director was not mentioned here, and so because of that, I was directed to verify the right authority and also to make corrections in the course list. I've done that. I've taken that step, and knew because it was not addressed to the director. It was the service was rejected. They did not accept the service. Now I've made corrections, and I've served the notice to the director.
By which order were you permitted to make such correction? Where is the forwarding letter?
My lord, order dated 11/10/23.
Where is that? Yes. Yes, Mr. Court Master, please come here. Where is the correspondence file regarding steps? Respondent number 5, how was he addressed? This one reduced. Is it open? No, no, it's not open yet. Director National Nonsense. See,
Yes, my lord.
order of 1110 permits you to,
Yes, my lord. And
no,
in line
listen,
with this order, I've taken steps and it's reflected in order 15.
please listen. I have not completed.
Yes, my lord.
111023 permits you to ascertain the authority
Yes,
to represent respondent number 5 and take steps.
yes, my lord.
But that does not cure the defect in your writ petition, wherein you just have written at serial number 5, National Blood Transfusion Council.
Yes, my lord. In line with this order, I've taken steps and the order is reflected in 15/11/2023.
Where is your amended cost title?
My lord, it's reflected in the order itself.
I've seen that, I'm reading that, but where is it? The amended cost title? Hmm?
My lord, it has been amended through registry.
Okay. Okay, respondent number 5 refused. Now, what is to be done? In respect of the other respondents, are they all represented?
Yes, my lord. My lord, here respondent number 6. Union of India their affidavit will be necessary.
Mr. Yangawati is there for 6. Where is your affidavit?
I have not filed.
When are you going to file?
I will give in 3 weeks time.
3 weeks time. Then 5 though is not appearing. Then what about 1, 2, 3 and 4?
They have filed their affidavit, my lord.
Who's appearing for them?
And Mojay, he's on leave today, my lord.
He appears for 1 to 4.
Yes.
Yeah, 1 to 4.
Nagaland State Blood Transfusion Center, Nagaland State AIDS Control, Mission Director, then Principal Secretary, all of them. Okay.
Yes, yes, my lord. He's
Okay.
appearing for 1 to 4.
Office note dated 14/12/2023 shows that notice sent to respondent number 5 has returned back unserved. with a postal note, inverted comma open, refused. Close inverted comma. Full stop. Under this circumstance, we are compelled to observe that notice shall be deemed served upon the respondent number 5. Mr. Gauhati, learned counsel, appears for.
Sorry for the interruption, Lordship. Unless the notice is served on the respondent number 5, because the respondent number 5 is one of the main respondent. So at least substitute notice will be issued. Because without the because I'm sorry. Because the respondent number 5, he is the respondent number 5 is the main respondent in fact.
Okay.
He should give the license so that the state respondents can operate the blood bank. So unless the respondent number 5 is present, so that is why I said I beg that a substitute notice may be issued.
But how do you serve notice to him when he
By a
doesn't want?
substitute notice to publication, Lordship.
When he does not want to, they don't want to
To
receive it.
publication, Lordship, because without the license, without the license from the blood transfusion council, a state cannot establish. I'm sorry, I'm replying on behalf of the ministry of the state. Without the license given by the National Blood Transfusion Council, state cannot establish a blood transfusion bank. That is.
May I please, Your Lord? My Lord, here the affidavit for clarification will be made by respondent number 6, Yunen, because their response is necessary here because this court is concerned with the blood component separator, which the state has already procured way back in 2016 to 17, but it has not been made functional because of the pending license. Now that license is, the state government has submitted in their affidavit that they are awaiting the license from the center. So respondent number 6 has to clarify whether and when that license will be granted.
All right. That you cancel from that under the circumstance, na? I dictated. Under the circumstances, what did I say? Please read.
Under the circumstances, we are compelled to observe that notice shall be deemed served upon respondent number 5.
Yes, you cancel that line. Please cancel it. Then thereafter, what did I say? After that, what did I say? Nothing. Only that much. Okay. The requirement to serve notice upon the respondent number 5 in a substituted manner will be decided at a later stage. To stop next para, it is seen that the respondent numbers 1 to 4 have already filed their counter affidavit, and they are represented by Mr. N. Mozui, learned counsel, who otherwise has submitted his leave of absence. To stop, the respondent number 6 is represented by Mr. Gauhati, learned CGC, and he submits that respondent number 5 will be a necessary party, and without response from respondent number 5, effective adjudication of the case will not be possible. To stop, he also prays for how much time? 3 weeks time to file counter affidavit on behalf of respondent number 6. Next para, as already stated, the requirement of serving notice upon respondent number 5 will be taken up. Respondent number 5 in a substituted manner will be taken up at a later stage. List the matter again after 3 weeks. You file a affidavit and you say what you want to say.
Yes, my lord,
If
if
we-
an endeavor can be met by
If we
respondent number
find,
6.
if we find it necessary, ultimately, I've left it open. We have left it open.
Ultimately, the license should be given by the respondent number 5. Though we are the central government, that the license is issued by the respondent number 5. So without a
You
license.
say that in your
Yes.
affidavit,
Yes,
then
Lord.
we'll consider. All
Yes.
right.
That's obliged.
For hearing from the supplementary cost list. Porter, item number 60.
May I please, Your Lordship?
Yes.
Lordship, yesterday I've given my submission also. In addition to that, I will just revise in brief. On 11/7/23, I was arrested by the police while I was coming home from Dimapur town. And thereafter, I was booked under Kohima PS case number 14/23. This Kohima PS case number 14/23 was registered on the basis of the suo motu FIR filed by the police personnel. Lordship, at the time of my arrest, nothing was seized from me.
What is the case number?
Case number WPC criminal number 14/23.
No, the police case number.
Police case number, sir. Lordship, I'm sorry, Lordship. Lordship, Kohima PS case number 14/0014/23.
Okay.
Under section 120 BIPC read with 25(1)A, 25(1)AA of the Arms Act and regulation 7(8) of the NSR, National Security Regulation, Nagaland Security Regulation. So, Lordship.
Where is this Kohima?
Kohima is.
It's a locality. It's a town.
Yes.
Locality.
Yes.
Dimapur.
Village, town.
It's a town.
Town. Under Chumukidima now.
Okay.
It's a village. So at the time of my arrest, Lordship, nothing was seized from me. From my possession, only one West Bengal number vehicle and 450 rupees was seized from me. Lordship, I will take you to page number 48. Page number 48. NHRF.
Yes.
Yeah. Lordship, you can see in serial number 5, my name appears there, Thingbam Shimra. It was on an above top right side, 11/7/23. On this day, I was arrested and serial number 10, Lordship can see 29,450 cash was seized from me and one vehicle bearing registration number WB02V2232 Maruti Suzuki Zen. Apart from this seizure item, nothing has been seized from me.
Okay.
Lordship, thereafter, I was forwarded to the Honorable Court on 12, and on subsequent date, I was given police remand. On 19/7/23, I was forwarded before the Chief Judicial Magistrate with a prayer by the IO for judicial custody. So with effect from 19/7 till date, I'm in judicial custody. Lordship, while I was in judicial custody in Central Jail, Dimapur.
Yes.
Lordship, I will take you to page number 43. Page number 4.
No, before that, can you just show us where's that prayer for remand in judicial custody?
Yes, Lordship.
19/7.
19/7, yes.
Okay, page 54, I think. '54, isn't it?
Lordship, just give me one.
The next year, K, this is the
Yes,
application.
yes, yes.
And where's the order?
Forwarding of this is the forwarding letter given by the IO on 19/7.
Where's the order?
Lordship, give me 1 minute.
Mr. Counsel, if it's not disputed, it's all right.
It is not disputed, Lordship.
Since 19/7, you are in judicial
Since
custody.
19/7, I am in judicial custody, Lordship. Lordship, while I was in judicial custody, on 2/9/23, I was served with some papers in the Central Jail, Dimapur. Lordship, I will take you to page number 29. On 2/9/23, I was served the order dated 31/8/23 passed by the Commissioner of Police and District Magistrate Dimapur. Along with this document, page number 30, the grounds for detention was given. A letter of approval sent by the district magistrate to the government for approval of the detention order dated 31/8/23. And a schedule in annexure in page number 32 by the Commissioner of Police, and a letter of information to me and page number 34. Lordship, apart from these documents, I was not furnished any other documents. Lordship, I am not well versed in English language. So I studied only up to class 7. The detaining authority has not explained to me in details as to what this document contains. It was only on 2/9/23 when my advocate visited the jail, Central Jail, Dimapur. I was explained that I have been booked under NSA, National Security Act 1980, by the Commissioner of Police and District Magistrate by an order dated 31/8/2023. Only on 2/9, my advocate has explained to me, then only I have learned that I have been booked under the National Security Act.
2/9, these documents were given to you.
Yes.
And on that day, you were explained.
Yes.
Before that, you did not know.
I know when at the time of handing over the Lordship, I was not explained by the detaining authority that I am booked under NSA and this is my detention order. Nothing as such.
But it's the same day.
Same day, yes. On and
2/9, you are given documents. And again on 2/9, you are explained by your counsel.
Yes.
So same day.
Yes, on the same day. On the same day.
It is not that you were given these documents and for many days you were there lost, not knowing what are these documents.
No, on 1/9, I think they have given the document. On 2/9, my counselors visited. On 1/9.
You said 2/9.
I beg your pardon, Lordship. It was on 1/9. So Lordship can see page number 29 in serial number 7, Lordship, below.
Just a minute. Page number?
Page number 29, the detention order. Below, Lordship can see copy to
Ah.
serial number 7. My personal copy was not served to me. It was the personal copy of the OC Kohima PS Dimapur.
Yes, then?
Then comes the grounds of detention. Then again, the page number 31, Lordship, approval order. Even here also in serial number 5 below, my personal copy was not given to me.
Okay.
Okay. Lordship, the detaining authority, while passing the detention order, nowhere mentioned that I was arrested on 11. Page number 29 and Annexure 1. Nowhere they have mentioned. May I read your Lordship?
Not required.
Okay. Lordship, then page number 30, Lordship can come to grounds of detention. It was not stated in details, but whereas Lordship's second paragraph. Now, therefore, it consists of section 5 of the said act. The undersigned hereby inform you that the said detention order has been made against you on the following grounds. Lordship, this should not be section 5. It should be section 5A. Section 5 is the place where the detainee will be kept.
5A means 5 capital A or
5,
small a?
5A capital A.
Capital A.
5 is power to regulate place and condition of detention after the detention order is passed. Five, power to regulate place and condition of detention. Every person in respect of whom a detention order has been made shall be made liable to be detained in such place and such condition, including conditions. So this is not a grounds of detention. So here I will say that this is non-application of mine. Then, Lordship, I will take you to page number 31. It should be section 5A instead of section 5. So this is also non-application of mine. Lordship then comes to page number 31. Page number 31. Page number 31, second paragraph. Lordship, I'll read. The subject SS Deputy Commander NS and I am Thingbang Simra, 45 years old, arrested for dealing in illegal arms and a possession of the same. Lordship, I humbly state that the seizure memo is very clear. Nothing was seized from my possession. As I have stated, shown in the page number 48 of Annexure, the seizure memo. Page number 48. From my possession, 29,450 rupees. Then one vehicle. That's it. And nothing was seized from me. Lordship, thereafter,
yes.
Lordship, thereafter, on 11/9/23, I have submitted my representation, page number 35, Lordship. Annexure 6. I have submitted my representation. Address to the number 1 is the Secretary, Ministry of Home Affairs, Central Government. The number 2 is the Chief Secretary, Nagaland. Number 3 is the Special Secretary, Home Department, Nagaland. Number 4 is Principal Secretary, Home Department, Nagaland. Chairman Advisory Board, NSA Act 1980, Nagaland. The Commissioner of Police and District Magistrate, Dimapur, Nagaland. I have submitted this representation through the Superintendent of Jail on 11/9/23. And the jailer authority, they have acknowledged in the body of the original receipt is here, Your Lordship.
Yes. we have seen.
594.
Then
So, Lordship, thereafter, on 15/9, I was furnished in the jail the approval letter. On 11/9, I have submitted my representation, and on 15/9, I have received from the jail authority page number 61, Lordship. On 15/9, I have received the order dated 11/9/23, passed by the respondent number 2, confirming my detention order dated 31/8/23, and my detention order was extended till 30/11/2023. Lordship, here also I want to point out one thing. If it is 3 months, it should not exceed 3 months in the one go. If it is 3 months, we calculate September is 30, October is 31, and November is 30. It becomes 91 days. My detention from the date of detention, it becomes 92 days. Lordship can see in the last paragraph, page number 61.
how many days? 91.
92 days. It should be 91 days, but I was detained for 92 days.
1 day excess.
1 day excess.
That's a bonus.
That's a bonus.
You got bonus.
So, Lordship, while handing over these documents to me, Annexure 7, Annexure 8, page number 61 to page number 103. These are the documents furnished to me on 15/9/23 till 103. From page number 61 to till 103. So the document which I was given at the time of my detention by order dated 31/8/23 by the Commissioner of Police and District Magistrate Dimapur, where the order dated 31/8/23, detention order, approval letter to the government, schedule, and information to me. And the document which you are not furnished to me, page number 68, Lordship. Page number 68. From page number 68 till 103, I was not furnished these documents at the time of passing the detention order dated 31/8/23. So, your lordship, I could not make an effective representation for non-supply of these documents to me. I could not make an effective document representation.
Before the passing of the approval.
Approval order. Before the passing of the approval order, when I was handed over the detention order dated 31/8/23 on 1/9/23 in the jail, I was given only 5 documents. Apart from these documents, no other document has been given to me. Thereafter, I have given my representation on 11/9. Thereafter, when I was given the approval letter order dated 11/9/23 on 15/9/23 in jail.
Your representation is 11/9.
11/9.
Approval order also 11/9.
11/9.
Both 11/9.
Both 11/9. But I have not received them.
So you received the documents after the approval order has been passed.
Yes, Lordship. Yes.
And therefore you could not make any representation.
Effective representation.
Effectively.
Yes, Lordship.
Okay.
Lordship, thereafter, my representation was rejected. Page number 104, Lordship. My representation was rejected on 29/9/23 and I have received on 10/10/2023 in the jail.
Yes.
Lordship, representation I have submitted on 11/9/23. Representation was rejected on 29/9/23 after a lapse of 19 days, Lordship. And even in the affidavit, government has admitted that it was 18 days, but it is 19 days with effect from 11. On 18/10, Lordship, on 18/10, page number 105, I was furnished the carbon copy of the rejection order by the central government on, which was on 13/10/20. I have received on 18/10. And on 19/10, page number 106, I was furnished the type copy of the rejection order by the central government. Page number 106.
When was this? On 19?
19 I have received.
18 carbon copy, 19 type copy.
Yes.
Okay.
That was rejected by order dated 13/10/23. Thereafter, Lordship, page number 107, the government of Nagaland has given me the letter dated 1st November 23, informing that my detention order has not been acceded to by the central government. I have received on 8/11/23. 8/11/23 from the government of Nagaland, letter dated 1/11/23. And along with that, the type copy of my rejection order by the central government was given. Thereafter, page number 109, order dated, confirmation order dated 17/11/23, served to me on 24/11/23. Confirmation order by the government of Nagaland, and it was served to me only on 24/11/23.
Yes.
Lordship, the schedule, the detaining authority has to prepare the schedule by himself. Lordship, I'll take you to page number 78. The detailed report submitted to the DCP by the IO of the case. And if we peruse the detailed report, it is nothing but a statement under 161. Detailed report of all the accused person. I am A5. Detailed report of all the accused person. Now, Lordship, page number 78, detailed report. Now, Lordship, this is nothing but the copy paste of the statement under 161. Then comes page number 68, Lordship.
Page
The-
number
Page number 68.
68.
68. The Deputy Commissioner of Police made a proposal to the Commissioner of Police for detention. If we see the contents of the proposal letter, Lordship, it is also copy paste from the detailed report submitted by the IO to the DCP. And the DCP copy pasted and again submitted to the Commissioner of Police for passing the detention order against the accused number 4. So here I will take you to the schedule again, Lordship. Page number 32. So in the schedule also, page number 32 and actually 4. In the schedule also, the Commissioner of Police, the statement under 161 was pasted here from second paragraph onwards. And neither in the schedule nor in the detention order, it is mentioned that I may be released on bail. Nowhere they have mentioned. Lordship can see in the last paragraph of schedule, page number 33. Page number 33 of the schedule, last paragraph, Lordship, I'll read. That the subject as a deputy colonel NSNI and Thingman Simram is presently under judicial custody at Central Jail, Dimapur. If he is not detained, he is likely to indulge in similar prejudicial activities unless an effective alternative measure is called for. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be booked under National Security Act. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state of Nagaland and maintenance of public order, the undersigned has ordered the detention of the subject under the said act. It is not mentioned that I will be likely to be released on bail. Only here it is mentioned that I am in judicial custody. Whereas in my detention order, it was not mentioned that I may be released on bail or I am in custody. That is, there is a total non-application of mine by the detaining authority. In the schedule, the detaining authority has stated that on the record made available by the sponsoring authority. Lordship, those records were not furnished to me so that I can make an effective representation. Those records were not furnished to me. So the detaining authority from the schedule came to the conclusion that this is the subjective satisfaction and passed the detention order 31/8/23.
Yes.
Lordship, I am illiterate. I studied only up to class 7. I am not well versed in English. I was not supplied the copies in the language I understand. And I was not explained in details by the detaining authority that I had been detained under the National Security Act. Now, Lordship, I'll come to Article 25, Article 22, Clause 5. Article 22, Clause 5.
Constitution. Get one more book.
May I read, Lordship?
Yes.
Before I read Clause 5, Lordship, I may be allowed to read sub-clause 4 first.
Yes.
No law providing for detention or preventive detention shall authorize the detention of a person for a longer period than 3 months, unless an advisory board consisting of the person who are or have been or are qualified to be appointed as a judge of a high court has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause for such detention. Provided that nothing in this sub-clause shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under sub-clause B of Clause 7, or such person is detained in accordance with the provisions of any law made by the Parliament under subsection A and B of Clause 7. Now I'll go to Clause 5. Here, Clause 4, I have read out because my detention order was supposed to be 3 months, but I was detained more than 3 months. My detention order was approved more than 3 months. Now, Clause 5. Clause 5. When any person is detained in persons of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. So, Clause 5, as per Clause 5, Lordship, I was not furnished the material on the basis of which the detaining authority came to the conclusion and detained me. Those documents was not furnished to me, and even I was not communicated. Here communicated, I will say that my detention order was rejected, Lordship, on 29/9/23 after a lapse of 19 days. So in line with this, Lordship, I will take you to National Security Act, Section 8. NSA Section 8. May I read, Lordship?
Yes.
Yes, section. Grounds of order of detention to be disclosed to persons affected by order. When a person is detained in pursuance of a detention order, the authority making the order shall, as soon as may be, but ordinarily not later than 5 days, and in exceptional circumstances, and for reasons to be recorded in writing, not later than 10 days from the date of detention, communicate to him the ground on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order to the appropriate government. Lordship, my detention order dated 31/8/23 was given to me only on 1/9/23. I received on 2/9. So at the time of handing over the detention order to me, I was given only 5 documents. Order dated 31/8/23, the approval letter, the grounds of detention, the schedule, and the information. Apart from these 5 documents, I was not served any other document, Lordship, on 2/9/23. So that is why I could not make an effective representation. So, Lordship, the approval order I have received on 15/9. Only with the approval order, I was given the report of the sponsoring authority. Only on 15, after a lapse of 16 days, Lordship, from the date of detention. So I could not make a effective representation. So within 5 days, maximum 10 days, within that period, they should have furnished me the copies so that I could make the effective representation as per clause 5 of Article 22. So this has been violated, Lordship. Lordship, then I will come to the NSA, Section 3. Page number, Section 2, Lordship, definition. I will just read out what is appropriate government. Section 2, definition. In this act, unless the context otherwise requires, appropriate government means as respect a detention order made by the central government or a person detained under such order, the central government, and as respect a detention order made by a state government or by an officer subordinate to a state government, or in respect or as respects a person detained under such order, the state government. Number B, detention order means an order made under Section 3. Now I'll take you to subsection 3 of Section 3, Lordship. Section 3 is with regard to 1 and 2 with regard to the order can be made under this. So subsection 3 is relevant for me. May I read, Lordship?
Yes.
If having regard to the circumstance prevailing or likely to prevail in any area within the local limits of the jurisdiction of a district magistrate or a commissioner of police, comma, the state government is satisfied that it is necessary to do, it may, by order in writing, direct that during such period as may be specified in the order, such district magistrate or commissioner of police may also, if satisfied as provided under subsection 2, exercise the powers conferred by the said subsection. May by order in writing from the government. So the government has not replied in the affidavit with regard to this. Lordship, now I'll read subclause 4 also.
What do you mean by this subclause 3?
3. Lordship, if having regard to the circumstances prevailing likely or likely to prevail in the area within the legal limit of the jurisdiction of a district magistrate or commissioner of police, the state government is satisfied that it is necessary to do, it may by order in writing. State government give a authorization letter to the commissioner of police. May by order in writing direct that during such period as may be specified in the order, such district magistrate or commissioner of police may also, if satisfied, as provided in subsection 2, exercise power conferred by the said subsection. Authorization letter has to be given by the government as per this lordship.
Are you saying that there is no such kind of authorization given to the Commissioner of Police?
Yes. They have not mentioned in the affidavit anything as such. They have not mentioned that.
But have you taken that plea?
I'm placing before your lordship.
No, today only you're placing.
Yeah.
But is there any averment in your writ petition
Yes,
saying that?
yes.
Under
yes.
what
In-
authority?
In my grounds, I have stated that the detaining authority has not given the authorization letter by the government. On this ground also, my detention is vitiated.
Show us.
Then I will come to subclause 5 lords.
Show us your
Okay,
ground.
okay.
Ground. Where's your ground?
Page number 25 of my writ petition. Roman 13, lordship. May I read? Page number 25 of my writ petition. Roman 13.
Yes.
For that the detaining authority can pass the detention order only when he is authorized by the order of the state government as provided under subsection 3(3) of the Act. Such authorization can only be given in accordance with the requirement laid down by law. In the absence of this prerequisite, the impeding detention order is vitious and liable to be quashed and set aside.
What is the reply?
Nothing has been stated. Nothing has been stated. Then I'll come to NSA, lordship, if your lordship.
Just a minute. Yes.
Subclause 5 of section 3, lordship. May I read, lordship?
Yes.
When any order is made or approved by the state government under this section, the state government shall within 7 days report the fact to the central government together with the grounds on which the order has been made and such other particulars as in the opinion of the state government have a bearing on the necessity of the order. I'll read again, lords. When any order is made or approved by the state government, approved. My detention order was approved on 11/9/23. The state government shall within 7 days report the fact to the central government together with the grounds of detention. So in the affidavit, nothing is stated here.
Yes.
Lordship, before I come to the authorities, I will come to the affidavit. Affidavit by the state government. So, lordship, the affidavit is sworn by one Abhijit Sinha, Principal Secretary, not by the detaining authority. I will adapt what my learned friend has yesterday submitted with regard to this. Only I will say that the averment made in the petition, the government has admitted maximum of my averments. Lordship can come to page number 2 of the government affidavit.
Yes.
Lordship, that with regard to statement made in para 1, 4, 5, 7, 8, 9, 12, and 16 and 17 of the writ petition, the answering deponent offers no comment as borne on by the records. Now, Lordship can see in my writ petition, page number 5, para number 2. It is with regard to my arrest. They have admitted. Para 4, with regard to my representation, they have admitted. 5, admitted. Then 7 also admitted. Para 8 also admitted. Para 9 admitted. Then 12, 16 and 17. These paragraphs they have admitted. Then Lordship, para 2 they have replied. Para 2 they have replied with regard to the whole story of the case. Then page number 4, paragraph 5, Lordship.
Yes.
Paragraph, in this para, they have denied para 3, 3, 6, and 10. And I am stating that I was in judicial custody in connection with the in my petition, writ petition, page number 6. They have denied, and here I am stating that in my para 3, I am stating that I was at that stage of passing the detention order dated 31/8/23. May I read, Lordship? Para 3 of my writ petition. That while the detainee was in judicial custody in connection with the aforesaid case, the order of detention was passed by the Commissioner of Police, District Magistrate Dimapur, Nagaland on 31/8 purportedly in excess of powers conferred by Section 3(3), subsection 3 of National Security Act 1980, hereinafter referred to as the Act. It be mentioned herein that papers were served upon the detainee, which included a letter dated 31/8/23 addressed to the Special Secretary, Home, Nagaland, Kohima by the Commissioner of Police and District Magistrate Dimapur, Nagaland, seeking for approval of the detention order dated 31/8/23 together with the grounds of detention. On 2/9/23, the detainee was served a copy of the aforesaid detention order number so and so, dated 31/8/23, and the grounds served upon the detainee along with the forwarding letter bearing number so and so, addressed to the Secretary, Special Secretary, Home, Nagaland, Kohima by Commissioner of Police and District Magistrate Dimapur for approval of the state government, a schedule attached to it, and a letter bearing number so and so, dated so and so, addressed to the detainee regarding the grounds of detention and informing the right of the detainee to make representation to appropriate authority as provided under subsection Article 22, Clause 5 of the Constitution of India. The above said documents served upon the detainee was a personal copy served to the OC. This is what I said. I have annexed these documents. I have annexed in 1, 2, 3, 4, 5. So the government has, in their affidavit, has denied these amendments. Then with regard to para 6, page number 9 of my petition. May I read?
Yes.
Page number 9. That along with my writ petition, they have denied. Along with the aforesaid approval order dated 11/9/23, the petitioner detainee was also served with some additional document on 15/9/23. The additional document which was served to the detainee on 15/9/23 and which you are not served along with the grounds of detention on 31/8/23 are proposal letter to the Commissioner of Police and District Magistrate Dimapur, Nagaland by the Deputy Commissioner of Police, DCP Chomukidima, Nagaland, bearing number so and so, CMD the 24th July 23. Detailed report submitted by the IO of the case addressed to the DCP Chomukidima dated 24/7/23. Statement of accused Thimban Simbram recorded under 161 CRPC. Suo moto FIR dated so and so. FIR under so and so. Crime detail from form dated so and so. Dated 11/7/23. Arrest court surrender dated so and so. 11/7/23. Checklist for arresting person under 41(1)(b)(2) CRPC. Revised format for joint interrogation. It is categorically stated here that the additional document mentioned above were not served furnished to the petitioner. Detainee, along with the grounds of detention, they order dated 31/8/23. However, on perusal of the suo moto FIR, it is mentioned that a huge amount of ammunition contained 1,500 numbers to so and so and 980 numbers of so and so ammunition were recovered from the vehicle and apprehended. 2 persons, namely Roshan Mope Jaliang, Joshan Jenny, and subsequently arrested Elizabeth Jinkai in the case. This environment also denied by the principal secretary who filed the affidavit.
No, denied, but what? Plain denied.
Yeah.
Plain denial.
Plain denial. There, I will just read the first line that in regard to the statement made in paragraph 3, 6, and 10 of the writ petition, vehemently denied. Vehemently denied.
No, that's okay. But apart from saying vehemently denied, some explanation has to be given, isn't it?
Yes.
You are saying categorically that these documents, additional documents, were not given to me.
Yeah.
Opposite party says, I deny. Is it sufficient?
It is not sufficient. Also.
So they have to explain.
Yeah, they have to
No,
explain.
we have given you. This is your acknowledgement. On so and so's date,
Yes.
we had given it to
Yes,
you like
yes.
that. That explanation is not there.
No, no, nothing. If your lordship permits, I will just read out. I'll just read out. It's a small paragraph.
Read out paragraph 5.
Paragraph 5.
We have read it. That's why I'm asking you.
So no explanation. Lordship, even paragraph 19, 20, 21, they have not even dared to reply also.
Dare to reply.
Yeah. Maybe they are scared. So let's see. This is my case. So the grounds which my learned friend yesterday has taken, I will adapt that also. The submissions, the authorities. I have some authorities, if your lord permits, in short. And lordship, one more thing. I will just highlight. My detention order was rejected after a lapse of 19 days. Government has admitted in their affidavit it is 18 days, but it is 19 days. With effect from 11/9, and it was rejected on 29/9. So it is 19 days delay of rejecting my representation, disposal of my representation.
Any explanation for that?
No. No, they said it is 18 days, it is that's it. Yeah. Then one more lordship, I will take 1 minute, 1.5 minute, lordship. Page number 6 of the affidavit. This is a small paragraph. Under what section of law I have been detained? It is mentioned here. I will just read out. That with regard to the statement made in para 1 to 16, Roman I to 16, and 22 of the writ petition are the grounds of submission of the petitioner are vehemently denied. The answering deponent humbly begs to state that the deponent was well aware of the detainee in judicial custody and fully satisfied. The material placed on record, and after thorough application of mind, the detention order was passed directing the detainee to be detained under section 120B, IPC, Red with 25(1) AAA. This is not the detaining section. This is the ordinary law. I was arrested, but they are saying that I am detained under so and so.
But this is the charge section.
Yes.
You are charged with this.
Yes, but they are saying that
Detention order is under 3.
detention order was passed directly detained under section so and so. Detention order was passed, they are saying. So this is also one of the lapses, I must say, filed in the affidavit. Then, Lordship, with regard to advisory board, the advisory board should have been constituted under section 9 of the NSA Act. Then the advisory board will decide under section 10.
At what stage do they come in, advisory board? At what stage? Once the detention order is passed,
Yes,
then the confirmation order approval has to be given by the government.
yes. Government has given the approval, and for confirmation order, they have sent it to the advisory board.
Advisory board has sat.
Advisory board has said, but no document in support of the affidavit has been furnished. When the report by the government, the representation along with the other grounds for detention or what other document, etc., was forwarded to the advisory board, was not mentioned here.
There is a provision for you to appear in person before the advisory board.
Yes, that also one of my ground in my.
If you pray that you should be heard in person,
Yes,
you can be allowed to be heard.
assisted by a friend.
Did you have any prayer like that?
Yes, I have in my grounds.
Were you heard in
No,
person?
I was heard, Lordship,
Heard in person?
heard in person,
Okay.
but I was not allowed to be assisted by a friend.
Is there any provision which says that you have to be assisted by a friend?
Yeah, there is a citation, 2007 volume 4 GLT. I will come to that later on, Lordship.
No, the very concept of being heard in person is that you should be heard personally so that there's no disturbances from anybody. You yourself should be able to project that this is my group.
No, that freedom was not given to me. All the detainees were lined up, and then the advisory board was there, so that's it.
No, I mean to say that if you say that you should be heard in person, why do you require another friend to assist you? Then the very concept of being heard in person goes. If you say that, give me one more person.
Lordship, because I'm not well versed in English. Only because of that.
No, is it a fact that they have spoken to you only in English?
I'm not aware of it. And I'm sure advisory board,
I don't think
either
so.
Nagamis.
Advisory board, what is the constitution of advisory board?
Advisory board is to be constituted by the government under section 9 of the NSA Act. May I read, Lordship?
3 persons.
3 persons, yes. One has to be a retired district high court judge. After the advisory board is constituted, then section 10. Section 10 says that reference to the advisory board. I will read out section 10, Lordship.
Yes.
Save as otherwise expressly provided in this act, in every case where a detention order has been made under this act, the appropriate government shall within 3 weeks from the date of detention of the person under the order placed before the advisory board constituted by it under section 9. The grounds on which the order has been made and the representation, if any, made by the person affected by the order, and in case where the order has been made by an officer mentioned in subsection 3 of section 3, also the report by such officer under subclause 4 of that section. Here in the affidavit, they have replied only that advisory board has submitted a report. The documents were sent to the advisory board. But what are the documents? No forwarding letter, nothing as such in support of this in the affidavit.
Okay. How long will you take further, Mr. Counsel?
Lordship, I'll take another 20 minutes.
20 minutes?
15 minutes. Only the authorities. That's it.
Your friends are also waiting for their
Yes,
case.
yes. Only,
I will take only 10 minutes. Only 10 minutes. Everything is covered.
Okay, then we'll come back in 5 minutes.
গরমতে বইব বেশি ঠান্ডা না আমি কি বলবো জানো
মুড়ি বলে দে একটা কুলি বাইরে
language citation দিয়ে দিবেন GLD 20
কই দেখা একটু পারি তাই মিন গুলি দিতে খাবো
blood na Akan sa laga sa dito japan ko na. So, atacamos a San Pedro. Oh, andi morning na. Gorong pani jamur ke. Sehun jan. Gorong pani jamur ke. Jamur बोल के कम से कम ना 40-50 हो jamur में गिरना झाग गिरा तो रास्ते पे नाइन्टी वन पूरा पहले तो 3 दिन 4 दिन भी आया सब हम तो 4 दिन 5 दिन आए 4 दिन 3 दिन आए मैं एक हफ्ता से 4 दिन आए नहीं तो दे दिया जस्टिस से मैं चुहा हम 1018 में थोड़ा ले लो तो খালি থাকি না সব লাগছে খালি দেখবে না Embudos happen. Medicine because no, he's deputy commissioner. No. Engineer. Good experience, brother. Commission secretary. उनका जगह पे अभी आसान नहीं पड़ गया ये तो ऐसे दिखता है कमीशन सेक्रेटरी के अंदर
এটাতে দুই তিন টাকা করে 17 আছে ওই আপনার আখিল গগৈ একটা দিদি হয়ে যাবে Central government तो किसी कोई नहीं था। कोई कॉलेज 24 दिन करेगी किसी करेगी किसी अपना 24 दिन না এটা সেন্ট্রাল গভর্নমেন্ট May I please, Lordship?
Yes.
Lordship, the affidavit filed by the central government in page number 3. Page number 3. That they have received letter dated 11/9/23 was received on 5/10/23. There is a delay of 24 days to reach the central government. I have submitted the representation on 11/9 to the jail superintendent. Affidavit page number 3.
Yes, which part?
Roman 1.
Huh? Roman 1?
Yes. Central government affidavit.
Oh, sorry, central government.
Yes.
Okay.
Page number 3, Roman 1.
Yes, yes.
A copy of undated representation of detainee arrested, attested by assistant jailer and forwarded by the senior superintendent of jail, Central Jail, Dimapur, white letter dated 11/9/23 was received in the section concerned of Ministry Home Affairs on 5/10/23 after a lapse of 24 days, Lordship.
Yes.
Now I'll come to the authorities.
Yes.
GLT 2021 volume 3.
Sorry?
GLT 2021 volume 3.
Page?
764. I'll come to page number 770 now. 770, Lordship.
Paragraph.
Paragraph 21.
This is regarding delay.
This is regarding language.
Huh?
Language.
Language?
Yes. Furnishing, I'll just read one small paragraph. Furnishing ground of detention to the detainee in the language the detainee understand is absolutely essential, and non-supply of grounds in any other language has been held to be violative of clause 5 of the Article 22 of the Constitution of India, and the Honorable Apex Court has been following this principle in so and so. Again, this is with regard to the language, violation of Article 22 clause 5.
You're saying that you are class 7 pass
Yes,
only? And
Yes.
you're not conversant with English?
yes, yes, yes. This is.
Then you're conversant with what language?
In my own dialect, I can be given, I am a
What-
Tangkul, so I can be given the Tangkul language also. Or I should have been explained, or I shouldn't have been, this is what the authority says.
Okay.
Then para 24 is with regard to para 24, with regard to the affidavit filed by the additional deputy commissioner. So yesterday my learned friend has submitted, so I will adapt that, Lordship. So here the detention order is quashed. Then 2020, volume 3, page number 780.
Two thousand?
2020, volume 3, page number 780.
What, GLT?
GLT, Lordship, all GLT.
780,
780.
paragraph?
Paragraph 567. This is with regard to non-furnishing of the full text of the document. If the paragraph is written, will it suffice, Lordship? Non-furnishing of full text of the documents. Paragraph 567. All right, Lordship. Five, 6, and 7. May I read, Lordship, or it will be all right. With regard to non-furnishing of the full text of the documents.
Yes, not required.
It's all right, Lordship.
Sorry.
Then page number 771, same book.
Seven, 7, 1. Yes.
Paragraph will be 18 subclause 9, 19, 21, 24, 25, 28, 29. Some more paragraphs are there. 18 subclause 9, 19, 21, 24, 25, 28, and 29. This is with regard to security of the state and maintenance of public order. May I repeat the paragraph, Lordship?
It's all right. Starts from
Paragraph 18 subclause 9. This is with regard to law and order security, public order.
So what has been laid down here?
May I read them, Lordship?
Yes, read.
Subclause 9. As observed by Hidayatullah Judge, as he was then was in Dr. Ram Manohar Lohia versus State of Bihar, AR 1966 SC 740. One has to imagine three concentric circles in order to understand the meaning and import of the above expression law and order. Represents the large circle within which is the next circle representing public order, and the smallest circle represents security of the state. It is then easy to see that an act may affect law and order but not public order, just as an act may affect public order but not security of the state. It is, in view of the above distinction, the Act defines the expression acting in any manner prejudicial to the security of the state and acting in any manner prejudicial to the maintenance of public order separately. An order of detention made either on the basis of that the detaining authority is satisfied that the person against whom the order is being made is acting in any manner prejudicial to the security of the state on the basis that he is satisfied that such person is acting in any manner prejudicial to the maintenance of public order, but which is attempted to be supported by placing reliance on both the basis in the ground furnished to the detainee has to be held to be an illegal one. Wide decision of this court in Gopal Chandra Ghosh versus Arif Ali, 1975, Volume 1, SCC 253, and Satya Brata Ghosh versus Arif Ali, 1974, 3, SCC 600. Then again, sir, I read para 19 also.
Yes, read.
Yeah. Relying on the case of GM Shah Supra, a division bench of Gauhati High Court in the case of Shyamal Das versus State of Tripura, reported in 2006, 3 GLT 512, 2007, 3 GLR 41, has held that a combined reading of the order of detention and the ground furnished to the detainee at the time of when the order of detention was made, the district magistrate either had no material which could reflect the detainee's activities were prejudicial to the security of the state, or if the detaining authority had such material, he did not propose to consider them. In a situation such as the present one, when there is not even an iota of material to show that the alleged activities of the detainee genuinely give rise to an apprehension of threat to the security of the state, the order of the detention cannot but be described as the one suffering from non-application of mind. Para 21. In the case in hand, the detaining authority has committed serious error in law, relying upon the cases which were of 6 years old and stale and cannot have any relevance to the past a detention order after 6 years for restraining him from committing any future offense under a grave of National Security Act. Lordship, I will shift to para 24 now.
Yes.
Para 24. In the instant case, according to us, none of the offences allegedly committed by the petitioner were so grave in nature that would be regarded as a threat to destabilize the government, prejudicial affecting the public order and security of the state. The offences, para 25, the offences as alleged committed by the petitioner in our opinion can well be confronted under Indian Penal Code. Our penal code is not so weak to counter and punish the accused indulged in committing such offences. To detain an accused under NSA Act, the detaining authority of the government is to keep in mind that the act and the activities of a person should be of such grave in nature that if he is not detained, then it will necessary communal disharmony, communal disharmony, social tension, extremist activities, industrial unrest, and increasing tendency on the part of the various interested parties to engineer agitation on different issues. The anti-social and anti-national element including secessionists, communal and pro-caste elements, and also other elements who had adversely influenced and affected the services essential to the community propose a grave challenge, particularly in respect of defense, security, public order, and service essential to the community. There are 28 clauses. For the reasons stated above, in the instant case, we find the detaining authority has come to a conclusion which is found to be quite unreasonable and throws a considerable doubt on the genuineness of the subjective satisfaction of the detaining authority, vitiating the validity of the detention order. We are unable to persuade ourselves to find out the live link between the prejudicial activities and the purpose of detention. Then para 29. Each and every offense under Indian Penal Code committed against the state is obviously a breach of law and order affecting the peace and tranquility. But some sporadic, isolated incident committed against some individuals should not be termed as an offense organized and aimed to destabilize the government, affecting the public and threat to the security of the state. The discretionary power vested to the detaining authority has to be exercised carefully and caution, and only then when it is justified to achieve the actual purpose and object enshrined in the statute itself. In the result, we allow the writ petition and NP detention orders issued by District Magistrate West Tripura, detaining authority, subsequently approval, set aside and quashed. Then I'll come to 2009.
So the sections of law under which they were booked was regarding commission of offences of criminal trespass, extortion, theft, voluntarily causing hurt. All that.
Yes.
Assault or use of criminal force to women with intent to disrobe. So for all
which
these.
paragraph?
It's in paragraph 8.
8.
So they were booked under National Security Act. I mean, they were detained under the National Security Act, but the alleged crimes to have been committed by them is under the IPC.
Yes. Same is the case with us.
So court said that it is not such a grave concern wherein the security of the state is threatened.
Yes, and public order.
And public order. So in your case, why you're relying upon this judgment is that you were.
They have given the grounds of detention, security of the state, and maintenance of public order.
And all that was seized from you is some cash and some vehicle.
Yeah, that is my personal money already given on Jimma to my wife.
Okay. Yes, any other authority?
Lordship, 2009, volume 4. I think my 2009 volume 4. GLT.
Page?
Lordship, this one my learned friend has yesterday he has referred. So I will rely on this, page number 216.
You give the citation.
Okay. 2009 volume 4 GLT 216.
Paragraph.
Para 18, 19, 20, 22. Delay in disposal of the representation. My learned friend has yesterday submitted that. And with regard to subjective satisfaction also.
This decision includes both.
Yes.
Yes.
Then I will come to SCC 2012, volume 7, page number 181.
Please repeat.
SCC 2012, volume 7, page number 181, 58912 paragraph.
2012 volume?
Volume 7, Lords. Page number 181.
Paragraph?
Paragraph 4, 5, 8 and 9 and 12. Small paragraphs. Page number 183, paragraph 4. This is with regard to detention order passed while I was in judicial custody. Paragraph 4, may I read, Lordship?
Yes.
The question of personal liberty of a person is sacrosanct, and state authority cannot be permitted to take it away without following the procedure prescribed by law. Otherwise, it would be violative of the fundamental rights granted under Article 21 and 22 of the Constitution. In Aya versus State of UP, this court held that the law preventive detention is based and could be described as a jurisdiction of suspicion and the compulsion of values of freedom of democratic society and of social order sometimes might compel a curtailment of individual liberty. Paragraph 5 is a bit bigger. Shall I come to para 8?
Okay.
Paragraph 5 also and para 8. This court, while deciding the case in A. Gita versus State of Tamil Nadu, relied on its earlier judgment, so and so, that the detaining authority should be awarded detainee is already in custody and he is likely to be released on bail. The conclusion that the detainee may be released on bail cannot be ipse dixit of the detaining authority. Its subjective satisfaction based on material normally should not be interfered with. In view of the above, it can be held that there is no provision in law to pass the detention order in respect of a person who is already in custody in respect of criminal case. However, if the detention order is challenged, the detaining authority has to satisfy the court the following facts. The authority was fully aware of the fact that the detainee was actually in custody. There was reliable material before the said authority on the basis of which it could have been reason to believe that there was a real possibility of his release on bail. And further, on being released, he would probably indulge in activities which are prejudicial to the public order. In view of the above, the authority felt it necessary to prevent him from indulging in any such activities and therefore detention order was necessary. In case either of these facts does not exist, the detention order would stand vitiated. The present case requires to be examined in the light of the aforesaid settled proposition. Para 12, Lordship. In Rekha versus State of Tamil Nadu, this court, while dealing with the issue, held a perusal of the above statement in para 4 of the ground of detention shows that no details have been given about the alleged similar cases in which bail was allegedly granted by the court concerned. Neither the date of the alleged bail orders has been mentioned therein, nor the bail application number, nor whether the bail orders were passed in respect of the co-accused on the same case, nor whether the bail orders were passed in respect of other co-accused in cases of the same footing as the cases of the accused. In our opinion, if details are given, the respondent authority about the alleged bail order in the similar cases, mentioning the date of order, the bail order number, whether the bail order was passed in respect of the co-accused in the same case, and whether the case of the co-accused was on the same footing as the case of the petitioner, then of course it could be argued that there is likelihood of the accused being released on bail. Because it is the normal practice of most courts that if a co-accused has been granted bail and his case is on the same footing as mere ipse dixit statement in the grounds of detention cannot sustain the detention order and has to be ignored. In our opinion, there is real possibility of release of a person on bail who is already in custody, provided he has moved a bail application which is pending. It follows logically, if no bail application is pending, then there is no likelihood of the person in custody being released on bail, and hence the detention order will be illegal. However, there can be an exception to this rule, that is, where the co-accused whose case stands on same footing had been granted bail. In such cases, the detaining authority can reasonably conclude that there is likelihood of the detainee being released on bail, even though no bail application of his is pending, since most courts normally grant bail on this ground. So here also the detention order is quashed and set aside.
How many more?
Lordship, I will just give this one only. The rest will be all that my learned friend yesterday, he has covered this one. This is with regard to delay in disposal of the detention order, GLT 2017 volume 5. The GLT 2017 volume 5. Akhil Gogoi versus State of Assam.
Page,
Yes.
page.
660.
Paragraph.
Paragraph 59, 63, 64, 66. 59, 63, 64, 66, 69, 79, 89.
Beautiful. 17.5. 717.5, correct.
May I read or we'll just note down the paragraph, Lordship. This is with regard to delay in disposal of the representation order. Paragraph 59. Page number 686.
It is regarding disposal of the representation
Yes, Lordship.
as well as the right to be informed
Yes.
that you can make representation.
Representation, yes.
In this case, perhaps he was not given that information.
No, I was given the information that I have the right to make a representation to the
No,
authorities.
in this Akhil Gogoi's case.
Yes, yes, yes.
He was not informed.
Yeah.
'59.
59.
Then
63, 64, 66, 69, 79, and 89.
These are basically recital of the laid down law by the Apex Court.
Yes, 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 Lordship. Here it is, there are some issues which the division bench has discussed. The issues are whether there has been unexplained delay in disposing the representation dated 27/9/17 before the state government and the chairman of the advisory board. And the second issue is whether the order of the detention so-and-so is vitiated for not providing the documents and material relied upon by the detaining authority arriving. This is at page number 689.
This was not a division bench, it's a single bench.
I'm sorry. Yes, single bench, Justice Bazir. Yes, single bench.
You need not read, we'll go into it, we'll look into it, okay?
I will read.
Not required.
Okay. Lordship, then 2015, volume 2. This will be last. There are more, but
You already said last, now this is what? Real last.
affidavit filed by the, that also my learned friend has given, I will adopt that one. Affidavit filed by the Chief Secretary.
Correct, that I think you have already given us.
But he is not the detaining authority. And Lordship, yesterday my
Just,
learned friend
you just give us the citation, that's all.
Yeah, my learned friend has given
Now regarding that affidavit, give us the citation.
1991,
1991.
1991, volume 1. Page number 64.
Volume 1 of what?
Volume 1991, volume 1, SCC.
Page.
Page 420, relevant paragraph.
No, you give me the
417. Paragraph will be 7, 8, and 11.
by the authority who has not detained.
Yes, yes. This is also explained about the delay. Then 2010 GLT volume 5, my learned friend has referred this. I will adapt that one. Page number 41.
2010.
Volume 5. Page number 41.
Para? Paragraph.
27, 28, 29.
This is on which issue?
Yeah.
On which issue?
This is with regard to grounds of deterrence irrelevant materials. And violation of Article 22, Clause 5. Para 22.23.
That's all?
Yes, my lord. My humble prayer will be to pass the detention order on the grounds which I have stated.
Okay.
Obliged, lordship.
May I please, Your Worship?
Yes.
My lord, I will adapt the submission made in the yesterday case. However, there are certain points to be clarified, my lord.
Yes.
Firstly, my lord, the petitioner, the council has said that, and the petitioner has also admitted that detention order and and other documents were received on 02/09/2023. They are also admitting, my lord. Here, my lord, the detention order was passed on 31/8/2023. And the copy was served to the petitioner on 2/9/2023. However, my lord, here the petitioner is contending that requisite documents was not furnished to the petitioner. That is why he could not make effective representation. That is the ground yes, my lord. My lord, here, but as per the records available in the as per the records, acknowledgement received is there, my lord. Acknowledgement received, it clearly says that
What does it say? Does it contain a list of documents received
yes,
by
my
him?
lord. Kindly allow me to with the I Sri Tingpam Simra, daughter, son of so and so, village so and so, acknowledge receipt of one set of detention order number so and so dated and its enclosure, and certify that the contents have been explained to me in the language I understand. That is the Nagamis. He understand the Nagamis. In presence of the undersigned witness, that is before the jail authority. Along with the detention order, all the record documents were furnished to the petitioner on 02/09/2023, and even explained in Nagamis. Since the petitioner he studied up to class 7 and he is conversant with Nagamis. So in Nagamis, the ground was explained to him. So there is no violation of section 8.
From where are you reading that? From your records?
From the reports.
You just mark it. Have you marked it?
Yes, my lord.
Flag it?
Yes.
Flag. It's flagged?
Yes.
Okay.
So my lord, there is no violation of section 8. As per the section 8 says that, your lordship may kindly see the section 8. When a person is detained in pursuance of detention order, the authority making the order shall, as soon as may be by ordinary, not later than 5 days, and in exceptional circumstances and for reason to be recorded in writing, not later than 10 days from the date of detention, communicate to him the ground on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order to the appropriate authority. So within the time, order was passed on 31st/8/2023, served to the petitioner on 2nd/9/2023. So there is no delay in serving the copy to the petitioner. And my lord, before the date of submission of representation was on 11/9/2023, and the approval order was passed on 11/9/2023. Before the petitioner received the approval order, the petitioner has already submitted his representation. Yes, that on the same day it was approved, and that the copy was served to the petitioner on 15/9/2023. That approval order. But the petitioner, what is submitting is, along with approval order, the remaining all documents were served to the petitioner only after approval order. But
No, at the time of submitting his representation,
Yes.
perhaps that was on 11.
Yes, 11.
He did not have all the documents. And approval order was passed on that same day.
Yes, my lord.
So he could not make effective representation. That is
Yeah.
what he's saying.
Yes, that's what he's saying. But our stand is, we have already served on 2nd/9/2023. Acknowledgement receipt is there.
No, acknowledgement is there. No doubt. But what I was asking you, if I may repeat, does the acknowledgement say that these documents, serial number 1, 2, 3, 4, 5, all these documents are received by me? It just says that along with the enclosed documents. So how do we know what are those documents enclosed? There is the gray area. He says he's got only about 5 documents.
Yes.
You say you're given all documents. How do we resolve that?
And Lordship, I have put my signature when I receive full documents.
List of documents.
In the next page, my lord, if you go through that acknowledgement received, in the next page, it mentioned that to the detainee information, the ground of detention. So my lord, specific is not mentioned. What other documents has been given to?
Correct. It cannot be.
Yes. But
No.
enclosure was served, that is the stand we are taking, already served to the petitioner. So, but before, in the approval order was passed on 11/9/2023. The petitioner received the approval order on 15/9/2023. That one we are in. But only the approval order we have served on 15. And secondly, my lord, authorization, in regard to authorization, my lord. My lord, the petitioner is submitting that without the authorization, the commissioner of police or the district magistrate cannot pass the order. But as per the act, my lord, when the act is there, what separate authorization is required? My lord? Act is very, very clear that under section 3, clause 3, it clearly says that section 3 says that district magistrate or commissioner of police has the authority to pass the order, but it valid for only 12 days. They have the authority. So that is why to approve the detention, they have to forward to the state government. So under this act, the commissioner of police or the district magistrate has passed the detention order.
No, it says by order in writing.
Yes, my lord.
So I'm sure there must be an order, although you're not saying that. There must be an order. Because if you read carefully, this is not the only case, isn't it? There are hundreds of cases wherein the commissioner has passed the detention order. So,
Well, section 3, clause 3. Kindly allow me to read, my lord.
at certain point of time, I've read it, that's why I'm telling you. So that is why at certain point of time, the government must have passed out some order that commissioner of police can detain under subsection 3. Now you are trying to say that it is implied, no separate order is required. So please read, let's see.
Clause 3. If having regard to the circumstances prevailing or likely to prevail in any area within the local limits of the jurisdiction of a district magistrate or a commissioner of police, the state government is satisfied that it is necessary so to do, it may by order in writing direct that during such period as may be specified in the order, such district magistrate or commissioner of police may also, if satisfied as provided in subsection 2, exercise the power conferred by the said subsection.
So what is subsection 2?
Subsection 2, it says, the central government or the state government may, if satisfied with respect to any person that with a view to preventing him from acting in any manner prejudicial to the security of the state or from acting in any manner prejudicial to the maintenance of public order or from acting in any manner prejudicial to the maintenance of supplies and service essential to the community, it is necessary so to do, make an order directing that such person be detained.
So it is a detention order.
Yes, my lord.
Now subsection 2 says that the central government and the state government. Now subsection 3 says that apart from the state government and the central government, the government of the state government can authorize, can permit the district magistrate or commissioner of police to exercise that power.
Yes.
If it is satisfied.
Yes, my lord.
By an order in writing. So he has made a specifically in the ground, I think ground number 13.
My lord, there must be.
You have not responded to it. You have by and large said that from ground number 1 to ground number so and so, there's nothing wrong, and you denied it. There must be something. Otherwise, why should the district magistrate and commissioner of police every time direct detention? So that is why
there must be order, but
that is why at the time of preparing the affidavit, you have to be very careful, because cases are decided in a writ petition through affidavits. So we cannot go out to the court and go to the office and start hunting for the order. So you are to take care that such kind of things are taken care of, isn't it? Yes, then.
Yes, and my lord, in regard to disposal of representation, my lord.
Yes.
Representation was submitted on 11/9/2023 and disposed the representation on 29/9/2023. So the
29/9.
Yes. Yes, the state is admitting that it took 18 days to dispose the representation.
What is the explanation?
The lordship mechanism in my affidavit in the possession.
Page
8, clause B. that there is no delay in considering or disposing the detainee representation. The detainee representation dated 11/19 was forwarded to the Senior Superintendent of Jail, Central Jail, Dimapur on 11/19/23. And accordingly, the representation was forwarded before the state government for consideration. And on 29/9/2023, the detainee representation was duly rejected by the state government on the ground that there is no merit in the prayer for consideration. During the process of files and taking decision by the competent authority, it took 18 days to dispose of the representation. Therefore, there is no delay in processing of the disposing of the detainee representation. It is a settled law, principle of law that the decision upon consideration of the representation should be independent.
Now, what does the act say?
My lord, as per the act, there is no limitation. There is no specific period when the representation should be disposed of. But uh,
Article 22 clause 5, Lordship. As soon as may be.
No, besides that, anything in the NSA?
No. It is only the authorities, the apex court has given the categorical decision. That's it. As soon as maybe means it should be, there should not be any delay.
Yes, Mr. Pom, what else? Mr. Gauhati is also there, isn't it? Okay. Mr. Pom,
my lord, yes.
you want to submit some more?
Yes. One more point, man. In regard to the advisory report, the petitioner is submitting that it was not heard before the advisory
Okay.
report.
We'll come back at 2 because there's one more case there.
Yes, ma'am.
Yes.
We're waiting for next item, but like may not reach, may not conclude.
Which item is that?
We're challenging the rules. Admission 6. Admission 6, the petitions are challenging the rules.
Okay,
So,
you have it some other day.
yeah,
Give it
otherwise,
as paid for by Mr. Azol is the matter again after a week.
after 2 weeks, man.
After 2 weeks. After 2 weeks.
No problem.
Okay.
Maja.
We'll come back at 2.
Yes.
Item 6 was, na? Hearing continue to work. Hearing continue to work, yeah. Hearing, aro.
Dui baji de aro logo.
Acha, thank you. Ambia so na honi do.
That's not a very focus. You will have that. You don't show money in this section.
কত মিথ্যা কথা কয়। এই যে আমাদের দেশে এপ্রুভাল হবে এটার লগে এগুলা দিছে। কি কয় আমি কোনো প্যারাগ্রাফ গুলো লিখে নাও এটাতেই তার ওই নাগামিজ ল্যাঙ্গুয়েজের সব কথা আইয়ে যাবে। Answer.
Yes, yes.
May I please, Lordship? Yes. Lordship, I beg to mention items 7 and 8, Your Lordship. To Your Lordship, there is the judgment order under challenge, Your Lordship.
Yes.
This is passed by Honorable Justice Devashish Bora. Lordship, in the next 2 weeks, you will be sitting. So I pray that the matter will be listed on 13/3. Today. you can not-
13/3, 7 and 8.
7 and 8.
Okay, as straightforward by Mr. T.V. Jamir, learned counsel for the appellant. List the matter on 13/3, 2024.
And item number 9 also, I am for the appellant, Your Lordship. Your Lordship, similar order on 13/3.
Okay, 9, similar order.
Similar 13. Of Lordship.
Yes, Mr. Paul.
May I please, Your Lordship, my lord, in regard to advisory report. Your Lordship, the petitioner has submitted that he was not heard in prison. But my lord, as per the record.
No, he was hurt.
Yes.
He said he was hurt.
Yeah.
Only thing that there was nobody to assist him.
Yes, but as per the record, it says that it was seated on 7/10/2023. Advisory report was seated on 7/10/2023, and that report was submitted on 10/10/2023.
Just a minute. Yes.
So report was submitted on 10/10/2023. Only the first paragraph, please allow me to read it. The detainee was heard in person in Nagamis, and he has confirmed that he was provided with the grounds of detention along with the enclosed papers, and that he had made representation that nil to the state government with respect to his detention. So
That
as per it,
that is
record. This is the report submitted by the advisory board. So before the advisory board, the petitioner has admitted that.
Please mark it. You have a flag with you?
I've already marked.
Flag is there, na?
Yes. Yes.
Okay. Then?
So as per the record, the advisory board has given an opinion that there is sufficient cause for detention for the petitioner under the preventive detention. So basing on this, the confirmation order was issued. And my lord, in regard to my subjective satisfaction, in my affidavit in opposition, like I've submitted yesterday, in my paragraph, it is. I'm referring on para 9. That is the submission. Yes.
Para 9 of your
yes
counter.
Affidavit in opposition. Yes.
See, Mr. Pom.
Yes, my lord.
The first line itself, you've not been careful. Just read.
Yes, my lord, in that here.
No, just read.
There is typical mistake.
That
section has not been mentioned.
No, not section. See, with regard to the statements made in paragraph number Roman 1 to Roman so and so.
Yes.
Of which paragraph?
Oh, that one.
You should have.
Yes.
You should have inserted.
Yes.
Paragraph number 21.
Yes.
Then thereafter only Roman 1.
Yes.
You have not been careful.
There is typing mistake, madam.
So
para 21. It is para 21. The
correct.
ground which was taken by the petition.
If you know that it was a typing mistake, you should have pointed it out to the court. At the outset, you should have pointed out. There are a few errors here and there. This is one, this is one, this is one. Isn't it?
Yes.
So you see, these are matters of dealing with the personal freedom of a person. We don't know who, XYZ, whoever it may be. If, as long as he's a citizen of India, he is entitled to be protected under the laws. And personal freedom, as we have already seen, it is very precious. It can be taken away, but except with due process of law. So that is why one has to be meticulous. Right from the date of investigation up till the filing of affidavit, you should be very meticulous. You cannot say that is paragraph A to Z, no reply, A to Z, no comments, A to Z. I strongly deny, like that. No? That will not do. You have to be very specific. So, I mean, we just pointed out broadly. Of course, we are not expressing any opinion as of now. Yes,
So
tell
here,
us.
here the petitioner has submitted that section has not been mentioned. That is the typing mistake, my lord. Here also that it should be section 3, clause 3.
You know what you should have done? You should have brought out one case law.
Yes.
There is also a case law which says that non-mentioning of section does not vitiate as long as power exists. You should find out those things to cover up your spelling mistake or typography mistake and all that. As long as power is there. You may say, I arrest you under section A, but actually it's section B. But as long as you have power under section A, your power to arrest is not vitiated. Like that. So there's a ruling like that also. You could have pressed that into service. Anyway.
So those are the submission which is mentioned in the affidavit of possession. So
records you have.
yes, records is with me.
Yesterday's case.
Yesterday one also record is with
Record
me.
is, where is the record?
Record.
Nobody mentioned, I just checked the last court's order. It
Yes.
says that you will produce the records.
My lord, I can produce tomorrow. That record, I can produce it tomorrow. Because yesterday I've
You return back?
Yes.
You return?
No, it is with me. It is with me.
Okay, you bring it tomorrow.
Yes.
We would like to see.
Yes. So that's all, man.
That's all.
There's no sample submission.
And your friend has left?
Yeah, he has
CGC?
adopted yesterday's younger. Lordship, with regard to what my learned friend has said regarding furnishing of documents. Lordship, on 15.9, this is the full set of the documents which they have furnished. Only on 15.9. Full set of the documents. Along with the approval order.
If it is full set, you're saying that it's incomplete.
No.
Now you say it's full set.
No. It is why, Your Lordship. On when I was furnished on 2.9, then only 5 documents were given to me. These documents were given to me only on 15.9.
Okay. 2.9 documents were different.
Only 5 documents.
Only 5 documents.
5 documents.
Okay.
That is also without covering letter. I have not taken those grounds.
Okay.
This is also without covering letter. So
On-
what are the
on-
details?
On 2.9, isn't it?
Yes. On 2.9, I have received only 5 documents.
2.9, you had an advocate.
Yes.
So advocate did not advise you.
Advocate has advised me.
Advocate is not experienced.
On 1.9, I have received. And on 2.9, my advocate has explained me in details that I am detained under NSA. Otherwise, I would not explain. They have written in Nagamese and I have not explained.
No. I'm not talking about the explanation. I'm asking you about the full set of documents.
Full set, yes.
On 1.9 or 2.9, when you got
1.9.
when you got the documents, and when on 2.9 you met your advocate, did he not examine your documents and say that, oh, these
Yes.
are not sufficient,
Yes.
there has to be other documents?
That is why in the representation also we have mentioned only these are the 5 documents we have received.
No, representation is different.
No, even to the accused also we have said these are the 5 documents. Yes, these are the 5 documents.
You
Even
should
the
be-
jail authorities have stated these are the documents.
You should demand.
That could have been. There are no.
You should have demanded.
Yes. So on 15.9.
Petitioner alone may not know, but his counsel was there.
Yes.
Counsel would have examined the documents and said, these are not sufficient. There has to be more documents. So once one small application, 2 lines will be sufficient. I have received documents, but these are incomplete. Give me the entire documents.
This will take another 10-15 days, Lordship.
No, no. If they don't give you, well and good.
Yeah. I understand.
Later
Lordship.
on, at this stage,
Yes,
right now,
yeah.
you can say,
Yes. Lordship.
they didn't give me, I asked, they did not give me.
Yes.
So they have no excuse
Yes, Lordship.
like that. No?
Then I accept.
That you could have done that.
Yes, Lordship.
So anyway, we cannot go by those things.
So only on
What-
15, yes, Lordship.
On 15, you got the full set.
Yes. Along
By-
with the approval order.
By that time, what happened?
I have already filed my representation on 11/9. So I could not give an effective representation, non-furnishing of materials.
Again,
Yes.
is there any bar in filing one more representation? The act says that you'll get only one chance.
Yeah.
After that, no more representation. Does it say so?
Oh,
If it doesn't say so, when you had the full set, then you should have said, oh, these are the documents. Let me write one more. You could have done that.
clause 5 says that immediately, as soon as possible, I should be furnished with the copies and then I make a representation. That's all.
Now, since you yourself have said that 2nd or 1st of August, it was incomplete. 5 documents. Only on 15,
Yes.
you got full set.
Correct.
15, after 15, you could have written one more representation. Seeing that, oh, there is something which we have not known, now let me write. So when I say you, it means you along with your counsel. Because you're not expect to write all these things while being in custody. It may be tough. So anyway, sum and substance, what you want to say is that you have not submitted the entire documents in time.
Yes.
And thereby causing great prejudice and prevented you from writing an effective representation. And moreover, the representation itself was considered after 18 days. It took 18 days.
Yes, 19 days. They are saying 18 days, but it is 19 days
Okay.
from the date of filing the representation. It is on 11/9 I have submitted. They are saying the 11 they have received. So it is 19 days.
You have been calculating everything very precisely, is it? 3 months also, 1 month, 1 day extra.
This is also serious. This is a very
92
stringent law.
days. Okay, that's it?
That's it.
All right. So we are not reserving the judgment. Okay, order will be passed. You will get within the course of this week itself. These 2 cases. I think one more case is there. That also will hear you. But just take down the counsel's name. Heard Mr.
Sharif Ahmed.
Sharif Ahmed, learned counsel for the petitioner. Mr. Who comes first? E. Tivapom, learned state counsel for the state respondents, and Mr. Gauhati, learned CGC for the Respondent Union of India. Orders shall be passed at a later stage. We just note their names, that's all. Okay.
Lordship, one more judgment if can be taken. I will not read out anything, only 2-3 paragraphs very important. Of this bench, the single bench, 2022 volume 2.
Mr. Counsel, see,
I'm sorry.
we are expecting you to cite some Supreme Court judgments. You are citing a single bench judgment before a division bench.
I give apology, Lordship. Deeply apology.
Leave that. You have cited enough judgments. Yes. You call the next case.
Item number 45.
By the way, where is your record? Give the records. Drag it along with the records, okay? Give me the records. What is your good name?
PB Paul.
Yes.
My lord, on low point, my lord, my case is fairly covered with the yesterday's case. Yesterday, all along, I was
Chasi,
sitting
you may-
here.
You may go, Chasi. I'll call you.
Yesterday, all along, I have listened to my learned colleague. So my case is clearly covered with his case. Your lordship.
All of you are arrested in that connection with that
Yes,
case.
same case, same. I'm the accused number 6. He's accused number 5, and he's 4, and yesterday was 5.
Who was keeping the bullets? You are the one.
No.
With whom? Bullets.
Bullets, your lordship, I am a police officer. I am a police officer, and I have been implicated in the case. Nothing has been recovered from my possession, whereas in the
Recovery was 1,000 bullets.
yes, your lordship, not from my possession.
Not from you.
No.
Who from whom then?
It is others.
Others means which one?
Accused number 1 and 2.
A1 and 2. Okay. Who is the counsel there? You are there. Okay. You are for item 46.
Yes, 46, madam.
Then who else is remaining?
46 and 46.
46 is for accused number 1
Yes, accused number 1.
and
accused
40
number 2 not yet listed.
not listed. 40, item 45 is accused number 4.
6.
Accused number 6.
Yes, sir.
Total how many accused?
6 accused.
Total 6 accused.
6 accused.
So 1 and 6, then the one which we dealt was 4.
4. And yesterday, that accused number 5.
Yesterday was accused number 5.
5, yes, yes.
And in one writ petition, state has not filed affidavit. It is still pending.
Which one?
Case number 1, case number 2 and
2. It's not listed today.
yes.
Anyway, please proceed.
Your lordship, Suomoto FIR was filed on 10/7/2023. That they apprehended one vehicle. This is SIT in Kohima village, and where these arms and ammunitions were recovered, and 3 persons were arrested. I am not that one. Subsequently, your lordship, I was arrested on 12/7/2023.
12/7/2023. Okay.
Involved in the implicating in the case.
Who's the petitioner? Wife.
Wife is the petitioner. My husband. My husband.
You are the wife. Petitioner is the wife. And in your case, you're the husband.
Yes. In my case, my husband was arrested. I'm the wife.
Oh, that's what.
Hmm.
So both of you are wives only. That case also wife. Yesterday's case also wife. Wife. Okay. Wife. Yes.
Because they are all inside the jail, so wives are moving. Now, your lordship, that proposal for detention of the detainee, my husband, that proposal was given on 24/7/2023. Now,
by whom?
By this deputy commissioner.
Before
Police.
Deputy Commissioner, IO had conducted some
Yes.
some investigation.
Yes.
Based on the investigation of the IO,
Yes, submitted.
Deputy Commissioner prepared
Yes.
a proposal
Yes.
to the Commissioner.
Commissioner.
Commissioner, upon seeing that, okay, said detain.
Detain.
Then within the next 12 days, it was written to the government.
Yes.
Government has approved. it.
Approved.
After approval, it has gone for confirmation
Confirmation.
through the advisory board.
Yes.
Advisory board says, okay, then the government confirms.
Yes.
Then in your case also, you have been detained till 28th of this month?
Yes.
All same?
All same.
Okay.
Everything is same order almost.
Okay.
Copy paste from here to there. Now, in my case, your lordship.
So what is the speciality in your case?
in my case, your lordship, number one, that subjective satisfaction was not there
Okay.
of the detaining order.
Okay.
Whatever this proposal has been made,
Hmm.
just copy paste the same. In the proposal, Your Lordship, in the proposal,
Yes.
it is opined that,
No, it is easy to say copy paste, but the thing is that
yes, Your
the,
Lordship, I
the,
beg,
the story has to be same. Because if the story are all different, then it becomes inconsistent. And there's no question of putting him in behind in custody.
now, Your Lordship, that in my cases, basing upon the statement given by the co-accused, I was arrested. And while I was in custody, it is said that I have under section 161 CRPC, I have given my statement. And basing upon the statement, my statement while I was in custody, that has been formulated. That subjective satisfaction was taken into consideration.
Okay.
Now, Your Lordship, I beg to take Your Lordship, page 45. First, Your Lordship, this is approval for detention. Dated
Recast.
Because my first term has been over, then I again extended. Then I had to file this recast.
Okay.
Page 45, Your Lordship.
Yes.
That dated 31st August 2003, this approval detention. Now, Your Lordship, to cut short, I beg to take Your Lordship the second para, this third para. The subject, Michael Yanthan, 41 years, was arrested for dealing in illegal ammunition and possession of the same. This is a wild allegation, and there is no nearest of the truth.
Now you say it's copy paste.
Everybody is like that here.
It happens also in other pleadings also.
Now, Your Lordship, I was not in possession.
No, see, 1 and 2 were in possession probably.
Yes, 1 and 2.
1 and 2 had were caught with the ammunition.
Yes.
But 1, 2, 3, 4, 5, 6 down the line.
Yes.
So when papers were prepared for the others also, same language, copy
Same
paste.
languages.
So this happened.
Yes, Your Lordship. Then
And where is the Caesar memo
Caesar memo is
to show that nothing was recovered from you?
To what is establish my stand. I was not having a Caesar memo with me. Now,
anything recovered from you?
Nothing. I beg to take Your Lordship to Annexure 1, page 23, FIR.
This Sumoto FIR?
Sumoto FIR.
Yes.
I should read, otherwise, Your Lordship, I am reading.
Please read.
Subject Sumoto FIR. I have the honor to state that on 10/7/2023 at around 22 hours, information was received from intelligent input regarding trafficking of ammunition at Kohima village, 6 mile Chumukidima area. Basing on the information, SOT swung into action and intercept one suspected vehicle, Boleno, bearing registration number such and such at Kohima village, during which huge amount of ammunition containing with 1,500 such and such, numbers 7.62 mm such and such, numbers 900, numbers 5.6 mm, which were packed inside 3 sack of rice bag, 2 green color Arham rice bag and 1 brown color swastik were recovered from the vehicle. In this connection, 2 persons were apprehended along with the vehicle, namely Roshan such and such Mopo Jilian, son of such and such village, Manipur, and Jason Jene, such and such, presently residing in 6 mile Chumokdima village. During preliminary inquiry, they revealed 1 person involved in the case. 1 person involved in the case. Subsequently, the involved person was also arrested, namely Elizabeth Jinkhui, such and such such and such district, such and such, 6 mile to Kohima. Along with one woman personnel of Kohima, PS, 3 smartphone was also seized from their possession at the time of arrest. Therefore, the apprehended individuals along with the seized ammunitions are being produced before your competent authority for the further investigation and necessary action.
So how many people were apprehended?
Three persons were apprehended there.
Occupants of the vehicle?
Yes, Your Lordship.
And one lady?
Yes, Your Lordship.
Yes.
Then this accused number 6, he was subsequently arrested as implicated by the co-accused.
Subsequently means on 12th?
On 12. And
After 2 days?
Incident took place on 10. On 12th, Your Lordship.
So when you were arrested, you were in possession of anything?
Nothing, Your Lordship.
What are you otherwise?
I am a police sub-inspector.
Sub-inspector?
Yes, Your Lordship.
Posted in?
Chumukidima.
Okay.
Police headquarters.
In charge of arms and ammunition?
Yes, Your Lordship.
Your duties in the armory?
Armory.
Armory. So you are suspect?
Yes.
What are these ammunition used in which gun? Anyone knows? This ammunition 7.62 mm and 5.56 mm are used in which gun?
5.56. I am not. I do not know that.
Mr. Thiba, you know, Gauhati, you know?
SLR.
SLR.
Self-loading rifle.
SLR or AK?
I am not sure, Your Lordship. I do not have knowledge of it.
All right.
No arms were recovered. Only ammunitions. Now, Your Lordship, then
you are arrested on 12th?
12th, Your Lordship.
Any document?
I have stated in my repetition.
Just tell us the sequence of events. That's what
Yes,
we want to
yes,
know.
Your Lordship, on 12/7/2023, I was arrested.
Yes.
Then on 24/7/2023, proposal for detention.
Then
31/8/2003, Commissioner of Police, District Magistrate ordered the detention. My husband's detention was ordered on 31/8/2023. Then, Your Lordship, on 11/9/2023, the Chief Secretary, Government of Nagaland, by the order number CON NSA 10/202364, Roman 2 of my list of dates. I have narrated everything. Chief Secretary has ordered the detention. Further. Then, Your Lordship, on 29/2023, I submitted my representation.
please come again. Date?
20/09/2023.
Yes.
And my representation was disposed on, rejected on 29/09/2023.
Huh?
Representation was disposed.
Which date?
29/29.
29. After 9 days.
After 9 days.
Okay.
29/9/2023. And though the representation I submitted on 29/2023, central government has sent a wireless message on 13, wireless message on 13/10/2023,
Rejecting.
rejecting which I received information on 19/10/23. Now, then your lordship, first detention was given on 31/8/2023 from for 90 days, 3 months, 3 months. However, my learned friend has stated the 91 days. So there was 1 day, in my case also 1 day excess.
92.
92, much obliged, your lordship. Then your lordship, second extension, it was given on 17/11/2023. 17/11/2023 for a period of another 3 months till 28/02/24.
Where is the order?
My
Page-
lord,
Page
page 56, last order.
56. No? 1711. You said 1711.
Huh.
56 is rejection.
17/11. 47. Confirmation. Oh,
47. Page 47.
yes. 47.
This is confirmation order.
Confirmation order from 1/12/2023 to 28.
So what is wrong in all these orders?
Your lordship,
You can be there for 1 year.
your lordship, first of all, your lordship, that representation, there is a delay.
Okay.
Not expeditiously disposed. Number one. Number two, subjective satisfaction is not there because, your lordship, this sponsoring authority is telling that there was recovery from my possession. And basing upon that, without going through the record and documents, detaining authority has accepted the same and acted basing upon that. That point that there was recovery from my possession. So there was no non-application of mind and subjective satisfaction was not there. There was no recovery from my possession. And then, your lordship, number one, subjective satisfaction. Number two, that there is a delay in disposal of the representation.
No recovery from you.
No recovery from my possession.
Non-application of mind.
Non-application of mind.
3 points.
3 points.
That's all.
That's all. In habeas corpus matter, if there is only one ground, then also there are canon of judgment when the apex court and this honorable court has also opined that, and that it cannot be sustained because non-application of mind and subjective satisfaction. Now, your lordship, that my learned friend has referred to cut short the precious time of this honorable court. Whatever these books have been referred by my learned friend, I am not repeating the same. It is covered my case. And beside this, your lordship, that probably yesterday one, year 1987 Supreme Court 1977 Moinuddin case.
Yeah, 1987.
Supreme Court.
Yes.
1977.
This was what was this?
Moinuddin that if any pleadings is not there in the habeas corpus petition, it should not be dealt with the regular writ petition. It can be taken out by the honorable, it can be accepted by the honorable court if there is any imperfect pleadings also. So this is one. Then, Your Lordship, 2010, GLT 2010. 2010 9 SCC, Your Lordship.
This was not referred to.
Pabem.
This was not referred to by.
2010 618. No, he has not referred that one.
2010.
5. 9. Supreme Court case SCC.
Okay.
618.
Paragraph
36.
This is on which point?
36. Delay.
Okay.
36 is a very short paragraph, Your Lordship. In the matter before us, a delay of 7 days has occurred in the forwarding of the representation. This may not be inordinate. However, at no stage has there been an explanation given for this delay.
Okay.
And here is, in my case, there is 9 days delay, and this central government, there is nearly 25 days delay. And
so there is no explanation?
No explanation. No explanation. Should I?
Not required. Representation file was sent, they received, and they rejected.
Yes.
That much only.
But that much only.
And it's due to all the office formalities.
Yes.
In 1-2 sentence like that.
Bus. That
okay.
Your Lordship, this GLT 2006 supplementary 1 577 para 23.
577?
Yes, Your Lordship.
Para?
This is division bench matter.
Yes.
Para 23.
This is on what point?
This is for subjective satisfaction.
Oh.
And this bail. In my case also, Your Lordship, the subjective satisfaction regarding bail. This is also a very small para. Should I read, Your Lordship?
Yes, please read.
In the present case, if we may reiterate, there were no materials available to the detaining authority or considered by the detaining authority for coming to the conclusion, which it did, that the detainee is likely to be released on bail in the near future. In our case, similarly, there is no evidence that I filed bail petition or no documents is there to establish that we are trying for bail or any of the co-accused has been released on bail. We have 6 co-accused. No one has filed bail.
You have not applied for bail?
No.
You have accepted that you are guilty?
I was trying because all of a sudden I have been taken into custody, Your Lordship. My Mrs. was out, so she was also, I was a police officer. So family got a major setback. Now.
But the allegation is very serious.
Now
you may be innocent, you may not be innocent, but see the allegation.
Now, Your Lordship, this allegation arms and ammunition. This what it is called 120B and this Arms Act 25 1A 1AA. This can be tried by under Arms Act by the ordinary court of law. And I am a police officer, Your Lordship. Until and unless it is proved that I have done this after reducing evidence, recording evidence, it cannot be said that I am guilty. Only I am an accused. So accusation does not mean that I am a guilty. Now, Your Lordship, until and unless it is proved that I am a guilty,
You are a suspect only.
I am a suspect only. I am an accused, Your Lordship.
And you cannot convict people on suspicion.
Yes, Your Lordship.
It has to be proved beyond reasonable doubt.
Yes, even this Evidence Act, Your Lordship, Indian Evidence Act, Section 25-26 is very much clear. One cannot be witness against his own commission of offense. Now, my statement has been recorded while I was in custody, and that is shown against me, that I have said like that, I have committed offense. So this cannot be taken, and there are some ruling also, authority also of this Honorable Court as well as of the Honorable Supreme Court, that such statement under Section 161 cannot be taken for preventive, what it is called, custody, preventive detention. Then Your Lordship, the satisfaction reached by an authority that a person is likely to be released on bail may be regarded as his subjective satisfaction. Honorable Supreme Court is, this Honorable Court as a point. Yet, the facts remains that in order to reach such a subjective satisfaction, the authority concerned must consider the materials placed before it objectively. In the case at hand, there was no room for reaching subjective satisfaction that the detainee was likely to be released on bail in the near future, inasmuch as there was no material placed before the detaining authority to enable it to objectively consider the same and arrived at a conclusion which it has reached, namely that the detainee is likely to be released on bail in near future. If there were any material which had impelled the detaining authority to form the opinion that the detainee was likely to be released on bail in the near future, such material ought to have been furnished to the detainee. Your Lordship, I have not been furnished with any document. My husband has not been furnished with any document that I would be released on bail. They are having proof. And also to this court, not only me, and it has not been furnished before this court also. Neither any such material was furnished to the petitioner, nor has any such material been made available to this court. There can therefore be no scope from the conclusion there was or support the detaining authority's conclusion that the detainee was likely to be released on bail in the near future. Situated thus, we are constrained to take the view that there was no material before the detaining authority to come to the conclusion which it had reached, namely that the detainee is likely to be released on bail in the near future. In the absence of any material pointing that the detainee was likely to be released on bail in the near future, no order of preventive detention could have been made against the petitioner. So solely only one ground it is liable to be set aside, Your Lordship, because I am a citizen of India, as Your Lordship has rightly observed, and my constitutional right cannot be taken away by that. That is why, Your Lordship, earlier MISA, POTA, all these black laws were thrown away. So, Your Lordship, I am a police officer. I was always doing, there is no adverse against me. I was doing, serving the people. And now I have been implicated since I was serving there. So I have been implicated. So I have to prove my innocence. Without any supporting, without any documents, they have put such allegation and they have put me inside the jail on preventive detention. And there is not a single instance, Your Lordship, that I was ever involved with any record is there. Your Lordship will appreciate that. There is no such record or report that I was ever involved with any secessionist or any other activities which is prejudicial or against the state.
Okay.
Now,
that's all.
My learned friend has given everything. So my learned friend is, so I think I should not repeat all this. He
Yes,
has
yes.
already given his.
Not required. not
Yes,
required.
your lordship.
Yes, respondents? You have the records in this
Yes,
case?
my lord, yeah.
Okay.
My lord, in regard to the subjective satisfaction and the disposal of representation, I have explained in my affidavit of opposition, my lord. I am not repeating, my lord.
Just show us the
Since I-
paragraph.
Since I, that in my affidavit in opposition, para 8, 9, I'm relying on para 8 and 9. Earlier, I have already submitted, so I'm not repeating, my lord. And my lord, in regard to, my lord, the petitioner is submitting that nothing was recovered from his possession. Yes, nothing was recovered from his possession, but there is direct involvement in the case, my lord. In the, your lordship, can in the one paragraph, I'll show you, my lord.
Yes.
In the statement given by the accused, page number 30. Page number in the writ petition, page number 30. Next 31. 31 para 1, 2, 3, 4. 11 para 4.
What is the name of the detainee? Name of-
Michael Jantan.
Michael Jantan.
Okay.
31 para 4. Further, he stated that, your lordship recorded?
Yes.
Yeah. Further, he stated that he collected 1,300 notes of 7.62 so-and-so light round ammunitions and 1,000 notes so-and-so around from the police central store and 200 notes of 7.62 so-and-so, which he has adjusted from different occasion and call up Lano Sanan, that is the accused number 5, and told him he has arranged the 1,500 notes of so-and-so ammunition. And the next para, after that, at around 5 July 2023, he called up accused number 5, Lano Sanan, and asked him where he was, at which Lano Sanan responded that he is at home, so he hired one auto Rexo and loaded 1,500 ammunitions and 1,000 notes of 5.56.45 mm from the police central store in 2 plastic rice bags, and when his resident in evening at around 700 hours after delivering the said ammunitions and went back. The last paragraph, he also stated that he has taken the 200 notes of 7 live round ammunition on different occasion and so and so live on from police central store on first week of July. My lord, here the accused is the man, he is the main culprit, my lord. He is the one who stole the ammunition from the central store. So, as per the facts and circumstances of the case, it shows that he is the main culprit and the direct involvement is there in the case. So, based on this report submitted by the IO, the detaining authority has compelled to pass the detention order. That is the only clarification I have to make. So, my lord, the humble submission is that there is no infirmity in passing the detention order, directing the detainee to detain under preventive act. And whatever procedure has been laid down in the act has been followed by the detaining authority. That is my humble submission, my lord.
Your lordship, in reply to the.
No, not now. Let him finish. You note it down. Please be comfortable. Take your seat.
Lordship, the two earlier writ petition and this present petition, the file were received on the same day. So one affidavit will cover all these 3. One affidavit will cover, though I have already filed my affidavit, but this.
You want to kill 3 birds with 1 stone?
No, Lordship, on the same day that the file, the case, the file was received on the same day. That is on 5th.
You have filed affidavit, isn't it?
Well, I filed my affidavit in all those cases.
Why is there a delay in receiving this representation, which I don't understand?
Yes, that is the problem, Your Worship.
Do you intend to cure it? What
I'll
is this?
inform the registry, Your Worship. I'll inform the ministry. As well as
Yes.
Otherwise, on the part of the Union of India, there is no delay, in fact.
Seeing the provision, you have to act very fast.
Yes, Lordship.
Even in genuine case, due to such sudden technicality, you may face difficulties.
No, Lord.
So your affidavit again says that 29 is the representation you have received on 5/10.
On 5, yes. So from 5 to 13, there is a delay of there is a 9 day, and there is a 1 Sunday also. So effectively, within 8 days, the representation was considered.
We are in a high-tech world now.
Yes, Lordship.
Not like those days where you have to make trunk call, you have to wait in a queue. To
Lordship,
send,
but
to send telegram also, you have to wait.
unless the state government give us the information, we cannot take any action. We do not know whether that this particular person is under detention or not.
I understand. It equally applies to Mr. Pom also. Your state government should do something about it. Yes.
That is all, Lordship. The same one affidavit will cover all the 3 cases that has already been taken up. Same date, or received on the same day. File was moved on the same day. On the same date.
One question.
No.
Once you receive the representation, how do you examine that?
Lordship, the file doesn't go directly to the secretary. It has to move from table to table, Lordship.
That's what, no? But your affidavit is only 4 or 5 pages.
That's why I've
I mean,
explained
what kind of exercise is undertaken? What kind of exercise is undertaken by the authority? That has to be at least, demonstrated.
Yes, Lordship.
Otherwise, it appears that we received the thing.
Let me read just one, brother. The undersecretary, with her comments, forwarded the file to the higher, just like that. The undersecretary has submitted the file, and it was forwarded to the higher. That is to the deputy secretary, joint secretary, and then the secretary. Because the file cannot go directly to the secretary. It has to go from table to table.
No,
as per the procedure, Lordship, the file cannot go up directly to the
No, that we understand. It has to go through proper channel.
No, Lord.
That is not what we are not on that. I was just asking you about how the authority concerned has applied his mind. Okay, this is the detention, this is the representation. I mean, some sort of exercise. Analyzing the situation should appear, isn't it?
That is as per the records submitted by the state government. The cases are being considered. Lordship.
Otherwise, it appears to be a very mechanical.
Mechanical. Yes, Lord.
Representation comes after 10 days, you send back reject. Comes reject, comes reject. So what sort of exercise is being done? That has to be explained somehow, isn't it? Anyway.
In fact, Lordship, without proper comments from the state government, the central government will not be able to give proper reply also. Because the central government depends on the documents, records submitted by the state government. So only on the basis of the records, the central government, they examine the merit of the case.
Okay.
Lordship.
Yes, you wanted to reply?
Your Lordship, that my learned friend has referred the statement. Your Lordship, statement was recorded under section 161 of CRPC. While I was in police custody, I was in custody. So that cannot be taken into consideration for subjective satisfaction. So
That point is already noted.
yes, Your Lordship. Much obliged, Your Lordship.
Please write down. Heard Mr.
PB.
PB Paul, Learned Counsel for the petitioner. Mr. E. Thivapom, Learned State Counsel, appearing for the state respondents, and Mr. Gauhati, Learned CGC, appearing for the respondent Union of India. Orders shall be passed later on.
Much obliged.
Yes.
For admission, item number 44.
Yeah, let us take up 46 first. We'll take
I
up.
beg your pardon.
We'll take up 46
Item
first,
number 46.
since it's related.
Please, my lord.
You're Mr.
M. Kasar.
Yes.
My lord, so this is the same case, so all are in the same line. So I would like to adopt the submission given by the previous learned councils. But allow me to give the sequence of the guests.
Sure.
My lord, I was arrested on 10/7/2023. And the arrest memo is on page page 46, my lord. I was arrested on 10/7/2023. And the Caesar memo is on page 49. Here.
You're the accused number 1.
Accused number 2, my lord.
Accused number 2.
Yes. Roshan.
Yes, 49.
Here, as per the Caesar memo, 1,500 numbers of 7.63 mm live ammunition. And second, 980 numbers of 5.56 mm live ammunition. Vehicle, Baleno, pairing number AS0-1/44, and ignition key 1, and then 3 mobile and 3 sack of rice bag. And then mobile phone number Oppo 1. So that is the seizure memo. Now here, my lord, after my arrest, the proposal letter written by Deputy Commissioner of Police Chamukidima to the Commissioner of Police and District Magistrate was written on 24/7/2023. That is page 25 to 60. That is the proposal letter written by the Deputy Commissioner of Police Chamukidima. And then in order, detention order, dated basing on this, the Commissioner of Police and District Magistrate Nagaland has passed in order, detention order. That is on page 61, Annex C. And on that day itself, the Commissioner of Police Dimapur sent or written a proposal letter for approval of detention. That is,
Mr. Kasar, just a minute.
yes, my lord.
Mr. Thiwa, can you just find out regarding the empowerment given to the Commissioner of Police? Like we had dealt with that issue,
Yes, yes.
that he has to be by in writing, he has to be authorized
Yes.
to pass such kind of orders. Just find out
Yes, I'll do
whether
that.
there is any such kind of orders in writing. Okay?
I'll do that.
Yes, 61.
Yes, my lord. So, proposal letter for approval of detention dated 31/8/2023, written by the Commissioner of Police to the Special Secretary Home, Nagaland, Kohima. That is on page 62 to 65, my lord. And then thereafter, approval order of detention dated 11/9/2023 was issued by the Chief Secretary to the Government of Nagaland. That is on page 66, my lord. And thereafter, I submitted my undated representation on 25/9/2023 to the Joint Secretary, Internal Security, to Division, Ministry of Home Affairs, Government of India, and the Special Secretary, Home Department, Political Branch, Nagaland, Kohima. That is on page 67 to 69, Annex F. My lord, my representation was rejected and the order has been issued 7/10/2023 by the Chief Secretary to the Government of Nagaland. That is page 70, Annex G. And type copy is on 71. And then rejection order by the Home New Delhi was sent through wireless message. That is on page 72. My lord, on page 73 to 74, here is the confirmation order dated 17/11/2023, issued by the Chief Secretary to the Government of Nagaland. So, my lord, that is the sequence. Now, my lord, I wouldn't take much time since all the submissions are in the same line, but I would like to this highlight the fact of the case. Here, Mr. Roshan Didone came down to Dimapur from Gauhati for some personal work on 10/7/2023. On reaching Dimapur, my lord, his cousin sister, that is accused number 1, Elizabeth Zingai, Lies Sophia, requested him to go and collect some consignment or package at 6 miles Sovema, Jammu Kashmir, from the residence of her cousin by the name Hani. So Mr. Roshan simply went out and collected the consignment goods as requested by her cousin sister. It is pertinent to mention hearing that, my lord, he doesn't know what was in the consignment, nor did his cousin sister Elizabeth Zinkai tell him that the consignment contains ammunition. While on the way, after collecting, heading towards his cousin sister's residence, the law enforcing agency, a police, intercepted him and conducted frisking. And upon checking the goods in the consignment, in his vehicle allegedly happened to be munition. Now, thereby, instantaneously, the person detained was arrested on 10/7/2023 in connection with Sovima BS case number 0014/2023 under section 120
Yes.
B IPC, so red bit. So while in judicial custody, Deputy Commissioner, as I have already mentioned, that Deputy Commissioner of Police Jammu Kashmir wrote a letter on 24/7/2000 to the Commissioner of Police and District Magistrate Nagaland stating that the subject or the accused Shari Roshan to book under NSA. And then the proposal here, the main ground, cut it short, my lord. Here, the person page 34. The main ground on which the arrest that person may be detained under NSA. So page 34 in my petition, my lord. Here, there are 3 grounds I have given, but particularly 3. Here, the subject are likely to move for bail, thus increasing the possibility of them enlarging on bail, and the possibility of subject indulging in criminal activities is real if allowed to move freely. Thus, every possibility of the subject indulging in the similar prejudicial activities which will be injurious to the maintenance of public order and have potential to affect the peaceful environment and normalcy of the life. So here, my detention basing on this, and this is also based copy-paste of the IO of the police, which has submitted to the Deputy Commissioner Jammu Kashmir. So he copy-paste and he has sent it to the Commissioner of Police, the same. So here, my lord, my detention was only because that I may be released on bail. However, till that I haven't applied any bail. How could they come to the conclusion that I will be released on bail? There is no subjective satisfaction at all. I may be applied bail and I may be released on bail. So that was their imagination. There is no material facts and evidence at the time of passing detention order by the Commissioner of Police. Simply, he reported the letter or proposal put up by the Deputy Commissioner of Police, and then he passed the detention order. And then on the same day, again, he wrote a proposal to the Secretary Home. So nothing material facts are there. It is only assumption and imagination. So there is no subjective satisfaction. Only thing is that I will be released on bail, but I haven't applied any bail till then. So detention under NSA is illegal. Therefore, it is liable to be set aside, caution set aside. And now the verdict short, my lord, since the previous learned council has given, so I don't have to repeat the same over again and again. All are same. So here, but I would like to, in support of my case, I would like to submit some citation rulings. Before that, before I give my submission, my lord, kindly turn page 17 my application.
Page?
17 and para 17. Page 17, para 17. My petition. Here is my law.
Yes.
It is further submitted that the detainee has already been in judicial custody in connection with the Kohima case, PS case number so and so, under section so and so, read with 7, 8 NSR. Now the offense alleged to be committed by the accused detainee is sufficient to be dealt with by the penal laws as well as the law under the Arms Act. It is already a settled position of law that if the offense committed by the accused, which can be dealt with by the criminal court, the preventive detention should not be passed as held in the case of Rekha versus State of Tamil Nadu through Secretary to the government and another reported in 2011, volume 5, SCC, page number 244. So here, these can be dealt with by the normal criminal court under penal law or any penal laws. There, allow me to read the paras, my lord, the sedition, which I have referred to. Particularly, para 27, my lord, 2011, volume 5, Supreme Court cases. Here, my lord, the detention order is served on a person already in jail. There should be a real possibility of release of a person on bail who is already in custody, provided that he has moved a bail application which is pending. Now, it follows logically that if no bail application is pending, then there is no likelihood of person in the custody being released on bail. So that is, it was held in this case. Now, mainly para,
You were
my
reading,
lord,
you were reading which paragraph?
my lord, may I take you to para 27? Para 27, my lord. May I read, my lord?
Yes.
In our opinion, there is a real possibility of release of a person on bail who is already in custody, provided he has moved a bail application which is pending. It follows logically that if no bail application is pending, then there is no likelihood of the person in custody being released on bail, and hence the detention order will be illegal. Oh, my lords, it is very clear. My detention is illegal. I haven't moved the bail. How could the detaining authority assume that I'll be released on bail? My lord, in support of my case, I would like to cite some few more citations. (2012), volume 2, SCC, page 176. Baras 23 to 28, 23, 24, 25, 26, 23, 28.
Yes.
So allow me to read only one para, 27. As has been observed in various cases of similar nature by this court, the personal liberty of an individual is the most precious and prized right guaranteed under Constitution Part 3 thereof. The state has been granted the power to curb such rights under criminal laws, as also under laws of the power to curb the such rights under criminal laws, as also under the laws of preventive detention, which therefore are required to be exercised with due caution as well as upon the proper applications of the fact as to whether such acts are in any way prejudicial to the interests and security of the state and its citizens, or seek disturb the public law and order, warranting the issuance of such order. An individual incident of the offense under penal code, however heinous, insufficient to make out of the case issuance of the order of preventive detention. So, my lord, these are my citations, and another citation, 2013, volume 5, GLT, page 787, eight five. 785. My lord, allow me to read para 5. Mr. Ezo, learned counsel for the petitioner, submits as follows. The communication to the detainee in regard to the ground of detention does not contain necessary information to the effect that the detainee was entitled to be represented by next friend, and as such, the right conferred on the detainee under Article 222, clause 5 of the Constitution of India has been violated. There was no meaningful compliance of the provisions of the Act as well as the Constitution, in as much as because of the failure on the part of the detaining authority to make the detainee aware about his right of being represented, the detainee has been prejudiced. And now, Roman number 3, my lord, I will jump to Roman number 3 there. It's the same para. My lord, let me avoid that. Let me come to 7, para 7. Para 7. After hearing the learned counsel for the parties and on perusal of the reports produced by Mr. Gauhati, it bears that the authorities acted in routine manner in informing the ground of detention of the detainee after having come to a finding on basis of the material that the petitioner was not involved in any unknown organization in manner. The trial of the petitioner under the Indian Penal Code for alleged extortion of money would have been sufficient. Materials warranting application section 3 of the national security are not discernible on the report. At least the materials did not make out nexus of the detention. Now, the next line, coming to the fact of this case, the detaining authority failed to inform the detainee that he has right of being represented by a next friend before the advisory report requirement held by the division bench of this court to be necessary for meaningful and compliance of provisions of the act. My lord, I was not given an opportunity to be represented by my friend. But the law is very clear. I have every right under the Constitution of India, Article 22, Section 5. I should be given an opportunity to offer, but in their ground of detention, my lord, let me take you to page 63. Page 63 of my petition. My lord, here, the last para, you are also informed that you have a right to make representation to detaining authority, central government and the state government through the concerned jail authorities. You also have the right to claim a personal hearing before the advisory board constituted by the state government under the aforesaid act. Here it mentioned, I have the right, but completely silence about that it can be represented by my friend, next friend. It's completely silent about this.
That friend part, is it provided in the act?
Yes, my lord, I have given the citation that
No, in the act. Does it say?
what right isn't it? But Article 22 Constitution of India provides that.
Article 22, clause
5.
Where in clause 5? I don't see any such provision. There is no such provision.
Yes. It simply mentioned that shall afford him that the earliest opportunity of making a representation against the order. When a person, clause 5, it says that when any person is detained in pursuance of an order made under any law providing a preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against them. But my lord, it is a settled law. That a friend, an ex-friend can be represented.
Whom do you want to represent you? Which friend?
Who knows law, my lord?
Do you have any friend in ready to represent you? Number one. Number two, have you taken that plea in your petition?
Yes.
My friend XYZ, they were ready to help me, but they did not permit. Anything like that?
But in my petition, I have already requested the vice report. But they have to amend the respondent. did not deny that.
Where is that?
Let me read the page.
Yes, come to page 14,
Yes.
paragraph 13.
Page 9, my lord.
9.
Yes, para 8. The last sentence. By the said undertaken representation, the detainee has also prayed to the detaining authority to provide assistance of the friend before the advisory report. NSA as invested under Article 22(5) of the Constitution of India. However, the same was not considered by the detaining authority. My representation was F. So that is my representation.
Where's the next page?
My representation is page 70, 67.
Undated.
67.
Undated.
My representation was rejected, stating that there is no merit.
No.
In my representation, my lord, I have
Where-
particularly denied all the allegations.
No, it's not that. Regarding to be represented by a friend, have you stated that?
No, in my representation, it's not stated.
Then there is no basis of your statement made in paragraph 8.
But in my statement, I have verbally requested the authority. that
No.
I may be allowed to represent by a friend.
See, you just read this sentence in paragraph 8.
Mhm.
By the said undated representation,
Yes.
the detainee has also prayed for detaining to the detaining authorities to provide assistance of a friend before the advisory board. So you say that you prayed in the representation, but in the representation, there is no mention.
So I'm sorry, my lord, actually it was verbally I have communicated.
Then you should write verbal. It has to be in black and white.
Actually, while presenting my representation, actually, I have requested.
Okay. So what is your next point?
So, my lord, my next citation that is also GLT 2013, volume 2, GLT, page 9. Para 12, 13, 12 and 13.
This is regarding?
This is, my lord, regarding maintenance of public order. Oh, my lord. May I read, my lord?
Yes.
Para 12. So in a given case, we have minorly examined the detention order, grounds of detention and relevant government file, which is placed before us by the learned government advocate, and are of the view that there is no material, not to speak of cogent material, for coming to the satisfaction that the petitioner detainee is likely to be released on bail. Surprisingly, in the ground of detention, the detaining authority did not even make a whisper regarding the reasons of coming to its satisfaction, that the petitioner detainee is likely to be released on bail, what is stated in the grounds of detention is his hypothesis and apprehension that in case petitioner detainee is released on bail, would continue to act in manner pursuant to the security of the state and maintenance of public order. What is required of detaining the detainee who is ready in custody is that there is material for coming to the satisfaction that the detainee is likely to be released on bail, and normal criminal proceedings would not be sufficient to deal with the judicial activities of the detainee over and above the requirement mentioned in panel in Paul, Manikram's gas, Supra, and Rekha's gas, Supra are also to be fulfilled for detaining the detainee who is already in custody. Now 13, for the foregoing reasons, we have no alternative except to set aside the invitation order and the confirmation.
Yes. You have wrongly cited 2013. It's 2012.
Yes. I'm sorry, my lord, this is 2012.
Yes, 2012.
Yes.
And when you have already cited Rekha's case, why do you cite all these? Supreme Court case is already there.
Yeah.
Even in this, Rekha's case also has been referred to. It's the same thing.
Okay, my lord. Then, yes, 2012 also. I use it, but let me just read it.
Which one?
Supreme Court cases 2012, volume 7, page 181.
This is on regarding
This is also detention regarding, my lord, the
bail.
yeah, bail. Particularly para 9, 12, and 15. 9, 12, 15.
This is also again slightly bit different, isn't it?
Yes, little
There was
bit.
one case in which other person similarly if given bail, so that presumption can be drawn that in this case bail, he might also take bail. So that is why detention. But in this case, which you are just trying to rely upon, it again says that merely because somebody has filed bail, you cannot presume that he also will file bail,
Yes.
isn't
Okay,
it?
so I will be released on bail. my lord. I haven't even applied bail yet.
No, what I was trying to say is that
Yes,
in one case,
Yes.
Supreme Court has said if somebody has filed bail on the same offense, it can be safely presumed that this present petitioner also, he may file bail. So detention is justified. But in this case, 2012 7 SCC, I think what you're going to read here is basically that just because somebody has been given bail, you cannot say that I also will be given bail.
Yes.
All right. I've got the point. Yes. Anyway, what is the relevant para?
Hello?
Relevant paragraph?
Relevant para is, my lord, 9, 12, and 15. Then, my lord, 2007, volume 4, GLD, page 200.
This is
This is also right of assistance of a friend before I place report. I can be assisted by a friend.
it's a division bench
Yes. my
or
lord,
single bench.
This is, I think this is division bench before UP Saha and A. Nirunu.
So this was relied upon by Justice Chaudhary in that case.
Yes, Imphal. This is
Imphal.
Imphal bench.
No. Justice M. Chaudhary had relied upon one. There was Kohima bench only. Mr. Zo's case, in fact. What is the paragraph?
My lord, paragraph fourteen. And 15. 14 and 15. My lord.
See, question is, where does the concept of next friend comes in? Was it by this judgment or some other judgment?
My lord, it is a settled law.
Oh, that is a sweeping statement. It's a settled law. But which law? Where? Please identify.
Actually, the concept comes from Constitution of India. So, though particularly it is not mentioned. It derived from that Article 22, verse 5.
In CCA rules, you have all these things. You have a right to be represented by a defense assistant. But here in NSA, before going to the advisory board or before the advisory board, you should have the company of your next friend. From where does it come? Because this judgment also does not say so. It just says that unless he's been informed that he can be heard in person with the next friend. Any idea, anybody? Next friend. Who has introduced next friend?
This judgment only.
Yes, this judgment we have seen, paragraph 14. It does not say that this next friend is available from this particular provision. It just says that it is not an empty formality to be heard by a board unless you are informed that you can appear before him with next of friend. Principles of natural justice will be infringed. That is what it says. So this judgment is the authority. Is it so?
But my lord, this judgment in regard to the assisted by the next kin to the detainee, that is, suppose if the detainee is illiterate and is not conversant with any language, suppose, then local dialect or no, then it can be assisted by the friend who is
No.
that is the opinion laid on by the Supreme Court.
In which case?
This is the case.
Well, this is
And
the
other
division.
cases, other cases also it's there.
This case is a division bench by, or this court, division bench.
If the detainee is literate person, then
Correct.
it cannot be assisted by any.
I'm not talking about the reason. I'm saying that what is the authority to say that you should bring one more? Reason is, of course, you can imagine, person is illiterate, he's not conversant, he's uneducated, language barrier is there. Then of course you need somebody.
My lord, that would be only a future. It is not so. Even a literate person also do not know layman. It can be represented by any educated. So, the concept of illiterate isn't right here. It implies to all. What is literate or illiterate? Well, my lord, just Supreme Court cases 2011, volume 5, which I have referred to earlier. Here, paragraph 14, 15, 16.
2011-5,
Yes,
SEC 244.
2011, volume 5, SEC 244.
You had only referred to paragraph 27.
I have referred to
27.
So 15, coming to that point, actually, who can be represented by an expert? Well, even here, not only literate, paragraph 15 says, right to liberty guaranteed by Article 21 implies that before a person is imprisoned, a trial must be ordinarily be held, giving him full opportunity hearing, and that too through a lawyer, whether it may be a literate or illiterate. Because a layman would not be able to reportedly properly defend himself except through a lawyer. So the concept is not illiterate or literate. There will be a literate or illiterate. So the justice said it should be represented by a proper person who can be represented effectively. So 14, 15, 16, and 17 talks about it.
It says right to liberty guaranteed by Article 21 implies that before a person is imprisoned, a trial must ordinarily be held, giving him full opportunity. This is an usual course. You must be given opportunity if you are imprisoned, that too by a lawyer. But in this case, we are talking about next friend. It may be a lawyer, maybe not a lawyer also. We don't know. So this is in the context of NSA also, no doubt. But the court has said that without proper trial and being defended by a lawyer, you cannot be imprisoned. We are into that context of personal hearing before the advisory board. So, all right, we'll consider all these things. Paragraph 15. That's it?
Yes, my lord. So these are my complete submission, and therefore my ground in this case is what page 20,
All right.
page 19, paragraph 20 in my petition.
Okay.
Much obliged.
You have not filed? Oh, you have filed. Mr. Kiba?
Yes, my lord, record. You mean the record, my lord?
Affidavit.
Affidavit, I'm relying on para 6, 7, 8, Para 6, 7 and 8. My lord, I want to clarify only one point, my lord, in regard to the appearing before the advisory board, my lord.
Yes.
To be assisted by the friend.
Mm.
My lord, here under section 11, NSA under section 11 of clause 4.
Mm.
It clearly says that nothing in this section shall entitle any person against whom a detention order has been made to appear by any legal practitioner. Section 11, clause 4.
Mm.
Nothing in this section shall entitle any person against whom a detention order has been made to appear by any legal practitioner in any manner connected with the reference to the advisory board and the proceedings of the advisory board and its report, excepting the part of the report in which the opinion of the advisory board is specified, shall be confidential.
Correct.
So, my lord, here if the
So-
detainer is illiterate
Mm.
and is not conversant with the local language or any language, he can be assisted by the friend, but the third person, not by the legal practitioner.
So
Yes.
that is why that reference in that paragraph 15 of that judgment
Yes.
is basically a general reference.
Yes, ma'am.
Perhaps not, it is not in relation to the special law.
Yes, my lord. Yes, ma'am.
This
Yes.
being a special law, this bar is there.
Yes, ma'am.
So that is why the reference has been made as next friend.
Yes.
All right.
Yes. So here the petitioner, his qualification is 12 plus as per the record. In the page number 27, your lordship, may kindly see the petition number 27. Accused number 2. Page number 27.
Mm.
Accused number 2.
Yes.
The fourth line. After passing out class 12, he came down to Dimapur and settled in Dimapur in Kohima village at his cousin sister house Elizabeth. After passing class 12, so he is literate person. So it is not necessary that he should be represented. He should be assisted by friend.
Yes. Anything else?
That is the only clarification I think. So there is no illegality in passing the detention order. That is my humble submission.
Yes.
As far as the union is concerned, the ministry, they have received the representation of the detainee who was considered and rejected. However, only the dates are different in this case, in this particular case.
Okay. $25,900.
It was received on 7/10/23.
1710.
17/10, and was rejected and was informed on 23/10/2023 that his application was not was rejected. And so on. And in the meantime, there was 2 days holiday, Saturday and Sunday in this case. That's all.
Okay. So we can close the chapter. Heard Mr. M. Kasar for the petitioner, learned counsel for the petitioner, Mr. E. Tibapom, learned state counsel for the state respondents, and Mr. Gauhati, learned CGC appearing for the respondent Union of India. Hearing completed, orders to be passed separately.
My lord, yes, records of yesterday case, I'll place it tomorrow.
Sure. And that query which I made,
Yes.
just find out.
Tomorrow.
Obliged, my lord.
May it please your lordships. My lord, item number 51, hearing. So I crave your indulgence to fix it on 3rd April.
Lordship, I have no objection.
I'm going out for 1 month.
Item number?
51.
51,
Lordship.
your
Hearing
lordship.
item number 51.
Okay, 3rd of March.
April, your lordship.
3rd of
March,
April.
I am going for my treatment.
Okay.
3rd April, consensus.
Mr. PB Paul, learned counsel for the respondent, submits that the matter may be posted for hearing on
3rd of
3rd
April.
April.
3rd April.
Lordship.
To stop the said prayer is not objected to by the learned counsel for the opposite party. In view of above, list the matter for hearing on 3rd of April.
Much obliged.
For admission, item number 44.
Yes, Mr. Muli.
Lord, the opposite party is not present today, so.
Okay. The appeal is by the Union of India.
Yes, my lord.
The opposite party will be writ petitioner.
No, yes, that petitioner.
Writ
I'm the
petitioner.
appellant, my lord.
Why have you filed this appeal?
My lord.
Why have you filed this appeal?
My lord, because.
What is this, service matter?
No, my lord, this is a recording census, my lord. Census. Population census, my lord.
Census?
Yes, my lord.
Direction is to conduct fresh census of this village within 90 days.
Yes, my lord.
This one you have filed appeal.
Yes, yes.
Why?
Because the judge has that according to the Census Act 1947 and Census Law 1990. My lord, normally the census, the initial census is to take every 10 years. After that, or prior to that, it could not be able to. So that because the birth rate and death rate is also, and different people are moving here and there, so that that could not be able to taken up within the specific period, my lord. So that I'm for appeal.
It is not possible to have census.
Yes. With reference that, my lord.
Separately.
Yes, my lord.
Okay. Any stay? No stay.
No statement.
No stay order.
There is.
There is stay order.
Yes, there is stay order.
When was it passed?
Actually, previously this one is handled by my learned friend. Now he is give up his ASJ So that I'm taking up this case, my lord, so that I have not gone through the records of this case.
Okay, when do you want it?
My lord, after 2 weeks.
Okay, as paid for by Mr. Zeten Muli, Lanet CGC. List the matter again after 2 weeks.
Much better.
Yes. Any other matter left today?